Any mention?
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 19, Lordship.
Yes.
Lordship, if this matter can be taken up after the 31st, after the Easter vacation, Lordship, the Learned Advocate General wants to argue physically, Lordship.
Yes.
Number 19 is similar with item number 18, my lord. Item number 18.
Connected, Lordship.
Connected matter. Both the matter will go there.
This is just the request made on behalf of the petitioner. Not objected by the non-accounts with respondents. This is after 2 weeks. After 2 weeks? Yes.
Lordship, Lordship.
My lord, I'm praying for item number 22 and 23, my lord. After a week, my lord.
With the other side.
I'm for the petitioner. State is on the other side.
21 and 22.
22 and 23, my lord. These are also same matters, my lord.
No objection, Your Lordship.
Hello.
2 weeks. Yes.
Please, Lordship. Please, Lordship. Lordship, I beg to mention item is 16. Lordship, I pray that this matter may be taken up after 3 weeks, Lordship.
No objection, Your Lordship.
So at the request of the petitioner, not objected to by the non-accounts with the respondents. After 3 weeks. Yes.
Upright.
Ali,
May I please, Your Lordship? I beg to mention item number 5. Similar issue is pending before the division bench, Your Lordship. So I'm praying for 4 weeks' time.
This is a matter about land acquisition.
Yes, Your Lordship.
Yes. The parties, Standard Council, appearing with the parties submit that the connected matter pending before the division bench is yet to be disputed. Paragraph MB of submission. This is matter 4 weeks. Yes.
Much obliged, Your Lordship.
My lord, I also beg to mention item number 24, my lord. This is, my lord, that POXO matter where the love affairs case derived. So 4 weeks, my lord, with the consent of the parties.
Yes.
Yes, 4 weeks. Obliged.
4 weeks.
My lord, I beg to mention item number 9, my lord. I pray for 2 weeks' time, my lord.
No, objection.
This is the prayer made on behalf of the state respondent. Not objected to by the land council with the appeal with the petitioner. This is matter after 2 weeks.
Deeply obliged.
Lordship, I beg to mention item number 8 of the main list, Lordship. I'm praying, Lordship, if this matter can come up after 1 week, Lordship. Item number 7, Lordship.
Item number
7, Lordship.
7.
Lordship.
7, I have an objection, my lord. If my lord may kindly produce the last order, my lord, of the Honorable Chief Justice. Last chance was given to them, my lord, for filing the affidavit. So this was not filed.
My lord, we have perused the affidavit, my lord. That will not be required, my lord.
So let it be
in our-
closed, my lord.
Let the matter come up. We'll just.
Fine.
Okay, my lord. My lord, similar prayer for item number 8, my lord. That is a different matter.
Yes.
8, my lord.
8. Who is appearing for the.
Again, it's a Nokma matter, my lord.
Who is for respondents?
For the private respondent number 4, Lord.
Dokbaship.
Nokma, my lord.
This is with Gabura.
This is Gabuda.
Go.
Issuance of Pata, in fact.
After 2 weeks, Lordship, I'm praying this matter can be taken up.
This also. At the request of the petitioner, not objected to by the respondents. Okay. After 2 weeks. Yes.
May it please Your Lordship. Your Lordship, item number 14, where Your Lordship had directed me to produce the records, bank records, Your Lordship.
Yes.
with due apologies, Your Lordship, the bank could not find those records, Your Lordship, and we are unable to produce. But in my affidavit, which I had filed in 2019, I've stated that, Your Lordship, that we have taken steps as per the RBI, but then the records are not available, Your Lordship. So, Your Lordship, this matter may come up for hearing.
Lordship, the records are essential, Lordship, because that's the primary
I can
contention.
understand if record they don't know, we'll do. I
Because
thought
it's an old,
Lordship.
it's an old
Lordship, may I
matter, Your
we'll see the,
Lordship.
we'll see the
Lordship.
legal consequence of
Yes, Your
non-production.
Lordship. We come up
So
for
you are-
hearing.
You'll proceed for hearing.
We'll proceed for hearing because I have been waiting for so long,
So
Your
it will be
Lordship.
taken up today only. You want it to be taken up today only.
Either today or after a week, Your Lordship.
Lordship, after a week, if I may brave.
Yes, say MS T. Yangi, learned senior counsel, appearing for the respondent number. You're a pen for
I'm for the respondents 1 and 2, Your Lordship.
submits that the records, comma, which was prepared to be produced before this court, comma, could not be located, and that view of the matter, and in view of the, and view of, and hence the matter needs to proceed without the production of the same, without production of the documents. Paragraph, just straightforward the parties. This is matter for hearing after 2 weeks. Yes.
Obliged,
Obliged, Your Lordship.
Lordship, I beg to make a mention of item 12, Lordship. Lordship, I
Yeah.
pray if this matter may come up after 2 weeks.
No problem with this.
Malad, we can see it
sir.
after 2 weeks, Malad.
At the request of the petitioner, not objected to by Learned Counsel appearing of the respondents, this is matter for 2 weeks.
Highly obliged, Lordship.
Malad.
May I please, Your Lordship? Your Lordship, I beg to mention item number 27. I pray this matter may come after 2 weeks.
No objections, Lordship.
2 weeks at the request of the petitioner. Item please. Yes.
Yes, sir. May it please, Your Lordship. Also, I beg to mention item number 17, Lordship. Lordship, in this matter, we were supposed to file an affidavit, bring on record whether funds were used from the SPV, Lordship. Lordship, I've met the officer last week, Lordship. I said I'll be getting the information by this week. I'll file it. Lordship, if Lordship grants me 1 week's time, Lordship, I'll bring the information.
For production of what?
For use of the funds from the SPV, Lordship. Special purpose
But
vehicle.
you need instruction.
Yes,
No,
Lordship.
no, you want time for what? For obtaining instruction.
Yes, Lordship. Just for filing the affidavit.
For filing the affidavit to bring
So
the
you have not
record.
filed.
No,
you are
Lordship,
supposed
we
to file
have.
an affidavit or additional affidavit or what?
Additional affidavit.
What is the requirement?
Lordship, for filing of affidavit, bring on record
What is
whether
affidavit or additional affidavit?
additional affidavit, Lordship.
There already exists one affidavit filed by you.
Yes, Lordship. The
This will
counter
come as
affidavit.
additional affidavit.
Affidavit replies already on record, Lordship.
Yes, that now you have to bring on to record what?
Additional affidavit, Lordship.
Mr. H. Kharwan, learned GA, for the state respondent submits that he is yet to obtain necessary instruction for filing additional affidavit. He is yet to receive necessary instruction for filing affidavit and prays for grant of some more time. Mr. Carlin, Learned Counsel appearing for the petitioner has no objection. Prayer allowed, list after 2 weeks. Yes.
Hello, Lordship.
Item number 1.
May I please?
Yes.
My lord, I have a short prayer. My lord, I feel that the prayer in the petition has to be changed a little, because by the prayer I have almost made this court a trial court. So I want to change the prayer a bit. I need a permission, man.
How you will do it in a criminal matter? What is
So
the
just to my aim is only that order of the lower court, nothing to do about the trial of the or the
that we
investigation
can
of the court.
understand,
That
but
portion
then
I want to
how
omit.
do we
man.
change prayer in a criminal case?
Is the order of the lower court which issued.
What is the provision? See, kindly understand the question of the court. Which law allows the prayer to be amended in a criminal proceeding? It is not a civil proceeding.
No, this is not a trial, of course. It's a revision against the order which has allowed the Zimma. That is the main issue. But here the prayer portion has seemed issuing arrest
You
order, and
understand what question?
that is for
what
the
is
trial.
the
So
question
that portion
put
I
in-
want to omit from the prayer portion.
Then
I
what?
want to amend the prayer in the.
What is the provision of amendment in criminal law? Show us.
Of course, then my verbal submissions may be
Show
considered.
us the law.
Yes.
The court needs law to allow a prayer. Court doesn't make its own law. You have to show us the law that we can do that.
On a verbal submission only, I'll have to change the prayer. This time does not.
That is up to you whether your submission you can change and to what extent it can mold it. That will be seen at the time of hearing.
But during submission only, I want to change the
that is-
prayer
at
portion.
least you are withdrawing that prayer to amend the prayer. Amend the prayer portion of the.
I wanted to amend the prayer portion.
No. We do not understand. It's a problem.
Which prayer you want to change?
You do not know what you say, what you intend to say. This court doesn't get anything.
The prayer portion, now I feel that it is not proper. It has to be changed, which I want to change either by my submissions before the court or by filing an affidavit to change the prayer.
No,
portion.
just
Or
tell us which way you are allowed in law to do that.
the revision, of course, there will not be. So I'll have to make the
That means,
submission in the court.
your
as-
prayer is
yes.
not valid in law. We will
Yes.
reject it.
Yes.
If you are making in prayer which is not sanctioned by law, who doesn't have any sanction of law, then definitely
Of
that
course,
will not be
inherent
effective.
power, I have not invoked in the petition. Inherent powers can always be
Inherent
invoked by the
power
court.
also has limit.
That is just to change the prayer portion.
Yes, Mr. Gautam.
My lord, here he has sought for revision against the order of Zimma. My lord, the Zimma was given to me. What has happened in this case is that the petitioner has been scammed.
Zimma of a vehicle.
Zimma of a vehicle. I am the registered owner of the vehicle. The vehicle is registered in my name. The petitioner has been scammed. What has happened is that somebody has mischievously posted the photograph of my vehicle in an online portal, eBay. So the petitioner, on the basis of that advertisement in the online portal, he has made payments to a certain third party. Now that third party is not made a party in these proceedings. Now
But
he
these are-
made a payment to the third party, and then thereafter, when he did not get delivery of the vehicle, he filed an FIR.
Third party is not a party in this.
He's not a party.
May I please,
The
my
person to
lords?
whom the payment is made is not a party. Now thereafter, he filed an FIR. He filed an FIR before the police station. Then, my lord, on the strength of the FIR, my lord, my vehicle was seized by the police. Now I came before the concerned court. I filed an application for Zimma, and the court, rightfully finding me to be the rightful owner on the basis of the documents that I had, released the vehicle to my Zimma. My lord, I had never sold my vehicle. I had never advertised my vehicle per
You
se.
have never entered
No,
into any.
no, I
agreement
have
with-
never entered.
You have not received any money from.
No, I have not received any money. In short, my lord, the petitioner has been scammed. He has.
Anyway, it has been released on.
Yes,
Zimma
it
to
is.
you.
It
It
has
is a-
been
it is
released.
a
It is in my
conditional
custody.
release. It's a conditional release.
Yes,
I feel you cannot dispose of the
No,
vehicle.
I have not disposed it of. The vehicle is in. Vehicle
is
is with me.
May I please, regarding that my learned friend may be misleading the court, giving false accounts to the court. Now the thing is that after filing of the FIR, the police had issued warrant, summons under Section 41, and in reply to that, respondent 2 and 3 personally came to Sadar PS and surrendered along with the vehicle. Thereafter, the father of the person in whose name the vehicle is registered, father applied for Zimma, and the court below allowed the Zimma to the father of the person who had the car registered under whose name. That is the mistake made by the lower court. And then the case has started. my
Normally,
lord,
law says it. See, normally law says that Jimma should be given
to the person
registered
who
owner,
has,
to the
but the
registered
petition
owner.
is by the father of the person, and the
No,
Zimma
no.
has been ordered to the father of the
It
person.
was released to a person who owns the vehicle, isn't
No,
it?
my lord, the
Then?
father of that person, to the father of that person. That is
And
respondent 3.
then whether the registered owner is challenging that Jimma.
No,
Registered owner.
before that, my lord, there are 3 dates when the court below
What
took
is
up
your
the
work
matter.
class? Who are you?
I am the informant of the case. The
No,
case
which
started
way?
from my information that I have paid money against that vehicle, and that is how the case started. And the court below had called for the records from the lower court.
Tell
And
us
thereafter,
when can order Jimma? When
at
can
least a notice to
you
me
see, this
ought to
court
have been
cannot go
issued
into all
before.
those factual things. Try to understand. We cannot go reappreciate things. Show us what is the illegality.
That the vehicle has not been granted in Zimma to the person who has the RC in his name.
Who is that person?
He is respondent to in whose name the vehicle is registered, but the
Are you
Zimma
there
has been given to respondent 3.
Are you there to advance the case of respondent number 2?
No, whatever. My case is that
You have
I should have been given a notice
You have no locus standi.
to hear on the
come back
Zimma
to
petition.
We'll come back. This court will rise for DV. We'll come back to this case. If you do not have any authorization for person number 2,
Because the case started because I have paid money for that vehicle.
Item number 1.
What happened? Yes. This matter has come up for orders, isn't it?
Yes.
We'll list it for hearing. Matter is ready for otherwise ready for hearing.
I wanted to change the prayer, my lord.
You want to change the prayer. Which way you do it, it's up to you.
Yes, sir. I may be allowed to change the prayer. Change the prayer portion only.
No, but then how? We will not allow you until unless you show us the law. Which way you can do.
I said at least invoking the inherent powers of the court, I may be allowed to
Invoking inherent,
amend
can
the
it be,
prayer portion.
can it be extended? Or like, can it be something like that, introducing a new provision in a law which is not available?
Otherwise, I'll make a submission only. That will be enough. Yes.
We'll list it for it. The party submit. That is ready for hearing. Let's wait for this after 3 weeks for hearing. Yes. Now,
Item number 2.
Yeah, I'm praying 2 weeks time to file an objection for respondent number 3.
what is the matter about?
Also, we have preferred a 482 quashing application because the offshoot of the FIR is a matrimonial dispute between the respondent number
It's
3
in
and
quashing of
yes, Your Lordship.
Who filed the FIR? You are
Husband. I'm the wife. The wife has
Here the
preferred.
allegation is that
I have stolen
that
some
the wife has stolen some landed
Land
document from the house of the husband. That is the allegation. And
the
police-
matter has been investigated.
Yes, Lord.
Charge sheeted.
Not,
not
yet.
yet. Lordship.
Investigation is complete.
And
Investigation
in
going
the
on.
meantime, the private respondent has filed another FIR. So
Can you just give her some more time for these things? Mr. Mrs. Oh, sorry, MS. GC Mara.
JT Sangmal.
Jadi Sangmal, Lara Council appealing to the restaurant number 3. Please for and granted further 2 weeks time for filing objection.
deeply.
Item number 3.
May it please your lordships. Lordship, on the earlier occasion, your lordship had directed us to take steps, your lordship, on respondent 1, 2, and 3, your lordship.
We are entering appearance on behalf of the respondent number 1, Lordship.
Lordship, as far as respondent number 3 is concerned, your lordship, it has been delivered to your lordship, but respondent number 2 is still awaiting service report from the post of lordship. Lordship, if your lordship can kindly allow us 1 week's time to file our affidavit of service, lordship,
So you'll verify the status on the
of respondent number 2, your lordship.
Okay. Mr. Channa, Learned Council was entered at 10 on behalf of the restaurant number 3. Restaurant number 1. Yes. The office note indicates that notice has been notice is duly served upon the restaurant number 3. However, none appears for the seat respondent. However, none appeared for the seat respondent. Stop. Insofar as restaurant number 2 is concerned, the related office note indicates the service report is yet to be received. Stop. The petitioner shall verify the status of service in respect of restaurant number 2 and file an affidavit to the effect. When?
After 2 weeks, lordship.
List. After after 2 weeks.
Your Lordship, interim order may continue, Lordship.
There's an interim order.
Yes, status quo, Lordship.
Interim order, if any past orders shall continue till the return about it.
Highly obliged, Lordship.
Item number 4.
May it please your Lordship. Lordship, service is complete upon all the respondents.
Anyone for 4 to 6?
Yeah, please, Your Lordship. I'm entering appearance for the 5 and 6, Your Lordship.
Respondent number?
Respondent number 5 and 6.
Who will appear for 4 and 6? 4. Who has not been received probably?
It has been, I have the tracking report with me.
No, but then tracking report we cannot take cognizance. Then you have to file an affidavit. Is it shown in the? Is it indicated in the office note that respondent number 4 has been served? Is there any indication apart from what you showing us, the tracking details?
Some time to get the certificate of service. Some time to.
There's nothing for respondent. You have to verify that, and then if you say that is served, then you have to obtain a certificate and file an affidavit.
And do the
Okay,
needful.
that's what you do. This tracking details will not do. You have to obtain a certificate from the postal authority then. Yes. MS. Your name, please.
A.D. Sharma, Amrita Devi Sharma.
MS A.D. Sharma, Learned Counsel. Learned. Your legal aid counsel.
Legal aid counsel.
Learned legal aid counsel. Presented appeared on behalf of the respondent number 5 and 6. Stop. However, there is no appearance on behalf of the respondent number 4. The official, the related official does not indicate that the said respondent number 4 was served or not. Step. The petitioner shall verify the status of service of notice upon the respondent number 4 and file an affidavit to that effect. Stop. List after 2 weeks. Verify and file.
Team resolution. Much obliged.
Hearing item number 6.
Just say, Mr. General, just present on behalf of the yes. Yes, Mr. Ma'am.
Last time it was part heard, and it used to be listed along with today's case, the item number 4 and 5.
There's no such order to take it together, isn't it?
The specific order is not there.
Only
but
because some, I think the
Some
submission was made before the court that it is some way connected with that.
yes, that was the.
Okay, so
I think it will be if we take together my lord, it will be better hearing.
no, is it whether is it related to that thing? Whether it will be dependent upon.
No, it's of the place. The road is same road, different petitioners.
Applicant.
But that is okay. But then that other case is item number
5.
Oh, that is the matter. Yes, you say that is connected with the. It is somehow connected with the matter pending before division.
Subject matter is.
But then how this matter can relate to matter pending before division? On what issue? What is the issue before the division?
In regard to the taken possession of the land for the purpose of construction of road of around 93 kilometers. So, so many inhabitants are affected in this.
Apart from you, there are others.
There are others also.
Yes.
So probably that division bench also, some matter has gone to division bench in regard to the acquisition
How
process.
can matter be before a division bench?
That is,
directly?
I have not.
Until and unless.
No. There, my lord. The issue, if I am not mistaken, my lord, the issue is whether the district council has the authority to issue patta or not. That is the matter.
No,
To be
that
decided in a division.
This has nothing to do.
No,
with
no,
it.
it is
Nothing
not.
to do. Here, it is not the case, my lord, where the district council has issued patta. Here only the district council has conducted an inquiry, and they say that the inquiry was not fair. My lord. Now, if the inquiry was not fair, they should have challenged that inquiry report also, because as per my understanding, my lord, this inquiry report was on the basis of an order, and they have not subsequently challenged this order. Neither they have challenged the inquiry report also.
Any affidavit filed against the inquiry report?
No, my lord. Affidavit was filed, my lord, but not challenging the entire inquiry, my lord. They are just saying that it was not a fair. In which way it was not fair, my lord, that again evidence has to be laid down. In this matter, the matter cannot be decided.
Your claim here is that your land has been taken,
Yes.
and then you have not been paid any compensation.
No.
Now your land has been taken. What is the area? What is the exact area of the land which has been taken?
This lump sum we have mentioned around 25 bigas.
And where is the location of that?
There is no location.
This is between. We have not exactly mentioned the specific. Whether if it is allowed, I may be allowed to file additional for specific.
2016.
Yes, my lord, I understand.
It's too late to hold. What the state affidavit says?
State affidavit says that it is it's a road comes under the ROW. So it was constructed in British time, and it was around 3-meter road. Now they have extended to 20 meters. Now they are saying that compensation to pay compensation does not arise because it was right of way.
Right of ways within the limit only. We have not encroached their land. No.
But there is no document showing, no document filed by the state showing that this place comes under the purview of the right of ways.
From middle of the road, it is 10 meter from both sides. It is
Who
not.
will prove the case? You have come to court. Whose duty is to onus is on whom? Now you have to give us the details of the proceedings, land acquisition, something. Now how many people have got from that thing, that acquisition, and how many have been deprived? Okay, you may not know how many have been deprived, but then how many % have been got? How many % have got compensation? And what is the project? What is the project under which it was done?
Project was done PWD by
You say that the road was extended without drawing up any proceeding.
Yes.
Because according to them, that is the what is the call?
ROW.
ROW.
Right of ways. So not necessary.
Then how this will be decided here? How this court will give a finding?
Melody, since it has not been processed under any of law, my lord.
They say that they have not taken your land. Now you say that your land has been taken.
Somewhere they said that some extension beyond right of ways also has been taken. In their affidavit is there, or inquiry report also is there. To some extent, it is extended beyond right of ways. Now, my lord, disputed here, my lord. that land has been already used without even notice also.
What is the length of the road? Total
Total
length of the road?
total is 93 kilometer. Ours
Which-
is
This
25.
entire this 93 kilometer,
Yes.
the road was
From
widened without any acquisition proceeding.
without any acquisition process.
And when this this thing was done,
It was done 2006, if I'm not mistaken.
when did you file this case?
I filed in 2016, but before this one is 2016. Before that, your lordship was another. The case was filed, but there was some defect, so it has to be filed again. But it is in the year 2000.
This 93 kilometers starts from which part to which part?
This is from Gadabada to Dalu via Ampati.
What is this communication, Mr. Hajarika? This is communication dated 16th August 2024.
Yes, communication, I have already submitted one copy to the court, my lord.
Yes. Now it shows that some acquisition proceeding was initiated
Yes, where we have
for
gone
ATV
beyond this
road
right
project.
of ways. In which place, some little place, we have gone beyond this right of ways. So we have to pay. So we have paid.
The places where you had to take land beyond that right of way,
Yes.
those places you have paid compensation.
Yes, ma'am.
Now you have drawn up this thing, land proceeding also, land acquisition proceeding, isn't it?
Yes. No, land acquisition proceeding was there, ma'am.
No, but then that is what it says, payments of compensation of so and so.
Yes.
Oh, that award was there, it was approved.
Yes.
Now, where are those related notification by which?
Notification, it is mentioned here only, my lord. I will go details.
Where are those?
Here, my lord, payment of compensation, second paragraph.
No, that is all okay. We have seen that.
Yes.
But
ma'am.
then how this proceeding was initiated?
Proceeding was initiated, my
speaks
lord,
about
because
the compensation.
it is there only that in addition to above this, it is also informed that the last paragraph, the land acquisition process of the aforesaid road is being taken up at the affected areas, my lord, last paragraph, where land has been used beyond the ROW only on request of the requiring body, that is
what is that last
WBD.
paragraph? Wait. The last paragraph means?
Yes.
Last paragraph of which?
Huh, my lord?
Last paragraph, which last paragraph?
Yes. It is that is from the notification they have given me, the letter.
What is the notification dated? 16th August.
Dated 16 August 2024.
Yes. And which paragraph you are reading?
The last paragraph, my lord.
Last paragraph is this is for your the favor of your information.
No, before that, my lord.
Yes.
Before that.
Yes.
Before that.
Yes.
It is also informed that the land acquisition process of the aforementioned road is being taken up at the affected areas where the land has been used beyond the ROW.
That is what we want to see.
Only on request of the requiring body, that is the PWT.
It's all right. It's all right. You show us the notification.
Oh.
Related notification of those proceedings.
Okay, my lord, I will call it about that. I have
Here
to.
only a mere statement.
Yes,
Isn't it?
Yes,
Of course, and this is a 2021.
Yes,
So definitely acquisition under new law.
Yes.
Not under the old act. So there has to be
Next paragraph.
Mr. Nath, you should have inquired about all those things. We have come here without anything. There is no details. Now it appears that the litigation proceeding was drawn.
No, my lord, it's not drawn, my lord.
That is what has been this thing. Have you received a copy of this letter dated
No,
16th August?
I have not received.
Mr. Hajarika, will you please give him a copy of this thing? If it
Okay.
is, I don't think there is any secret information. So it may not come under strictly this thing, this privileged document.
Yes,
May not be. So you can give him a copy of this.
Okay. Okay, I'll provide today.
And then you also bring on record those papers. Otherwise, how we will decide?
Okay, my lord.
But then
I'll
it will be
contact them.
difficult, Mr. Na. Probably after looking at the entire papers and all, you have to amend your petition. And now this case is pending for 10 years now.
My lord, if I'm allowed.
And if you say the land was taken up in 2006.
6.
Yes. And now this is, they speak about an accusation which was initiated, rather payment, which was made in 2021, much after your institution of your writ petition.
That is not.
So that is something, which way relate this with this?
If I can add something on this, my learned senior is projecting a case of Magupara Aking.
Yes.
Magupara Aking doesn't extend to 100 kilometers. It will be a particular area.
Yeah, exactly. We can understand.
Yes, if the learned senior from the government who is representing my lord, Mr. Hazarika, if he can place the record, my lord.
See. As far as this letter is concerned, have you seen the letter? That's
I've seen, my lord.
See,
Now,
see. One thing is that it says that the project is ADB route project.
Yes.
Garovada to Dalu starts for 93 kilometers.
Yes. Exactly.
So if any accusation is drawn, accusation proceeding is drawn,
Yes.
then definitely it will be for this area.
Yes.
And this will, okay, so there will not be a separate proceeding for certain parts.
No, my lord. The name of the village.
Yes.
The name of the village.
So
where
that
the-
is, see, we can
that
find
has
it
to
out.
be ascertained from the record, my lord.
Wait. Once we see the notices, then only can find out which were the areas
Yes.
which were sought to be acquired.
Exactly.
So this can be done only after production of the
Produce
record.
of the record.
Yes. Yes.
This has become a never-ending kind of thing, Mr. Hajarika. You do not know, everything is haphazard. And Mr. Nath also has filed a case in 2016, which way this 2021 basically concerns you.
My lord, that was.
This is a letter. Please give him a copy of this letter. Let him go through
Okay.
this. You say 93 kilometers. It was work was done for this 93 kilometers in 2006.
Yes.
Now here it is shown that the compensation is paid in 2021 only.
We have
And
not
your
received any
petition came in
compensation.
2016.
We have not received any compensation.
So that is surprising.
In 2000,
If any compensation is paid in 2021, you should have raised your voice there. Should have raised your objection there only.
we had no information about the payment of compensation.
If you say that your litigation proceeding was drawn, so definitely it must have been published. It was given wide
Yes, ma'am.
publicity.
Okay, I will call for it.
Had Learned Counsel appearing for the parties at some length. Had Learned Counsel appearing for the parties, not at some length. Mr. Richard Nath, Learned Counsel with the petitioner submits. The claim made by the writ petitioners for payment of compensation is in relation to widening of road from Garovada to Dalu area. For an approximate length of 93 kilometers. And the land of the petitioners falling within that area. were taken over without any payment of compensation. Stop. Mr. Hajarika, learned GM, appearing for the state respondents, however disputes the submission made on behalf of the petitioner, and submits that the widening of the road for the particular area was done under the ADB, A capital, D capital, B capital, road project, Garavada to Dalu. And for Dalu, for which compensation, due compensation has been paid. In the year 2021. Is it correct? 2021, shall we say 2021 or we do not know? Just see. Because here paragraph subpara 2 and subpara 3, it refers to payment of compensation to officials.
Yes, but list of the person are there, my lord, with me. Affected person.
These compensations were paid when?
Order is
There are
in 2019, my lord.
9 persons, isn't it?
Yes.
There's a list of 9 persons, isn't it?
Yes, 9% and another 4% also, 13%.
What we said just last part, Mr. ADB road project. Hmm. It is 2019 it should be. 2017, the year 2019. And the petitioners land have not taken over by the state at any point of time. Stop. Paragraph. As the related document with regard to the acquisition of land and payment of compensation submitted by the learned counsel for the submitted by the learned GA for the state are not available on record. Stop. The learned GA shall bring on records all the details, all the documents relating to the initiation of
yes, land acquisition notification
and payment of compensation and details of payment of compensation. What is it? Just last line. by filing an additional affidavit. Stop. How much time you will be needing?
3 weeks, my lord.
Just say as per for
this copy.
the learned GA. 3 years time is granted for doing the needful. Stop. List accordingly. You should have done some work. You have just come to the court without any homework.
My lord, this
You filed
that
case.
information
It appears that payment has been made much after you filed a writ petition.
But
And
we
you
have
have no knowledge about that.
no information we have received, my lord. Either
See,
from our client nor
The
from
presumption
their
will
side.
be that normally a land acquisition proceeding takes place after writ publication is made.
Yes.
So if you say that you do not know that, that goes against your
No,
argument.
that publication was not made.
It was
Acquisition was
proper
not-
for you to raise your objection there, not here.
Item number 7.
All right.
My lord, may kindly peruse order dated 28/3/2025, my lord.
Yes.
Your Lordship,
Last
I'm
chance
praying
was
for some
given.
time in this matter, Your Lordship, because the petitioner, they are from Garo
Wait,
Hills.
just a minute. Just let me go through it. This matter was pending before the Chief Justice for some time.
Yes, it was taken up only for one date, I think, by the Honorable Chief Justice. So, as per the order dated 23rd August 2019, they were supposed to file an affidavit showing their blood lineage with the Nokka, my lord.
Yes.
Here is the case, my lord, where after the mother has given the throne of the Aking, my lord, to the daughter. They have an objection
28 CC as a last chance.
as a last chance.
Trying
Now-
to file an affidavit to controvert the assertion of the respondent number 5 and 6 that the
Yes.
petitioner has no blood relation.
And the time was granted from 2019. From 23rd August 2019. They was directed to file this affidavit.
Yes.
Your Lordship, the petitioners here, they are from Garo Hills, Your Lordship. So I'm
See,
praying.
last chance is given. We cannot help. Last chance is last chance. We'll
Your
dismiss
Lordship,
it.
either way, the petitioners, they are the Maharis, Your Lordship.
We can
They are-
understand.
Your
But
Lordship,
then
in-
once order has been passed, this will
Your
amount to disrespecting the court order. Yes. By order dated 28/2025. Come on, the last opportunity was granted to the petitioner to file an affidavit to controvert the assertion of the respondent number 5 and 6 that the petitioner has no blood relation with the Nokma. What you said? By order dated so and so? The office note dated 4/4/2025 indicates. No, it is just say it is submitted. Just do not submit it. It is submitted by the learned counsel for the respondents that till date no such affidavit has been filed by the petitioner. MS Karwarlang,
Your Lordship.
learned counsel appear for the petitioner. Please for grant of some more time for filing the required affidavit. Stop. However, the prayer has been vehemently opposed by Mr. S. The Learned Counsel appearing for the respondent number 1 to 3. Stop. It is also been pointed out by Mr. Day that the time for filing the affidavit was granted since 23rd August 2019, 23rd August 2019, 23 2019. Stop. Paragraph. Stop. Taking into consideration the above aspect of the matter, and since a last opportunity was granted the petitioner, this court is not inclined to grant any further time to the petitioner for filing affidavit. Stop. The writ petition as such stands dismissed for default.
Hello, Mr.
Item number 10.
Or you can argue the matter without the affidavit. But then this will not. Yes.
Wait, please, Your Lordship. Lordship, on the last occasion, Lordship had directed us to file an affidavit, but we're still awaiting instructions from the Ministry of Home Affairs. Lordship, I pray that some time may be given to us for the same.
You have not filed affidavit?
Affidavit is required. Your Lordship has sought.
Yes. So no affidavit has been filed?
No, Lordship. I pray that some time may be given to us for the same.
Yes. Mr. Nampu?
Affidavit will be necessary.
Okay. MS Sobra, Learned Counsel appearing for the respondents to place for and granted some. How much time you want?
Lordship, 3 weeks.
No objection.
Granted for the 3 weeks time for filing an affidavit in terms of previous order dated 6/2025. Yes.
Hello.
Item number 11.
My lord, in this matter, state has filed the affidavit to clarify the points direct by this court. To clarify, Lordship, kindly see the order dated 26 June 2024. Elaborate order has been passed by my lord.
26 June 2024.
Yes, 24.
Relevant para is para 8.
Yes.
No, but then this is order is passed in which?
This is
WPC number, my lord.
473.
473.
2019.
473.
This is item 10 and item 15. 11 and 15.
Para 8, my lord. Relevant para.
This is a long order.
A long order, my lord. After long hearing, there was a extensive hearing, man, before
Yes.
my read, man. The existence of the aforesaid situation requires that a detailed affidavit be filed in this matter by a reasonable officer holding the rank of Secretary Education Department or the State Project Director, Meghalaya, disclosing clearly the applicable norms and procedure to be followed in appointment of teachers in upper primary schools under the SSA scheme, and whether the officers holding the rank of Joint District Mission Coordinator SSA has the authority to accord approval to the appointment of teachers under the SSA scheme by ignoring the stipulation made in the memo dated Census 2023. 13. The affidavit shall also diverge in clear terms the stand of the government with regard to the validity of the appointment and approval made in favor of the petitioner as well as the respondent number 7.
Yes.
So these are the two clarifications sought. Number one, disclose the procedure and norms. Number two, about the stand of the government with regard to my appointment and appointment of the.
What is this stipulation in the memo dated 10/6/2023? What is that memo about?
They say that the joint DMC has no power to keep appointment. In view of that matter, they have filed the affidavit.
Here there was an approval by the Joint District
Joint DMC.
Mission Coordinator.
Yes,
But then
yes.
as the memo basically diverts him from doing so.
Yes, yes. In view of that conflict.
Okay, so what affidavit has been
And
filed?
the affidavit they have filed, my lord. My lord, can you see that we have received this affidavit on 17 October 2024.
This affidavit was filed on 17th October.
17 October.
Why it has come after so many things? This court has basically forgotten what was the thing. It is 6 months now.
So para 3 my lord, deals with the sanction posts. 3 sanction posts are there.
No, what is the affidavit? What is the relevant part of the
Now,
affidavit?
relevant part, Lordship, can you see para 4 and 5?
Para 5.
Para 4 and 5. Start from para 4.
Yes.
On application norms and procedures for the appointment of teachers in SSA and upper primary schools.
Para 4.
Para 4.
Achha. No, that is para 4.
Yes, it talks about the procedure norms.
Okay, yes.
Well, Mary.
Yes.
The deponent respectfully submits that when any school is brought under the SSA scheme as a prerequisite and as per standard practice, norms and procedure, a new school managing committee should have been constituted, which subsequently has to be approved by the competent authority. In this regard, the competent authority for granting approval to the SMC is a district mission coordinator for brevity or the district joint mission coordinator. Hence, after the approval, the newly appointed managing committee is authorized to select and recommend the appointment of the 3 teachers mentioned above. The names of the 3 teachers are then to be forwarded to the competent.
No, this is the particular this thing referring to this.
Yes.
3 teachers means.
But in the SSA
No, the
school,
query of the court was with regard to the what is the law.
but here the state is dealing with the sanction. There are 3 sanction posts. Now the court query is what is the procedure for appointment of the teachers. Now it will come to this in that paragraph, my lord. Subsequent page, lines, it will come. Authority for records and endorsement.
See, so far as the first line of the first few lines of the
Yes,
paragraph
it is
4
not
is
concerned.
concerned.
Yes.
This is in general statement.
In
It
general
is with
statement.
regard to this thing.
Yes.
About this thing.
Yes.
Okay.
There is no dispute between the parties also. My lord, for records, the enforcement after which an agreement is required to be signed by the candidate, school, and the government represented by the DMC or the Joint District Mission Coordinator. Thereafter, the president and or the secretary, ex-officio member of the managing committee, issues appointment orders. The appointed teachers then submit their joining reports and join the school. However, as far as the founding teachers of the school are concerned, they are normally allowed to continue in service as long as they are qualified. Now, if I gather properly here, first, my lord, the SMC will be constituted, approved by the government, and SMC will go for selection. And after selection, they will forward it to the government for endorsement for record purposes. Thereafter, my lord, there would be an agreement by three parties. One is the selected candidates, SMC.
Once approval comes, then only.
My lord, it says, my lord, it didn't say approval.
After this election,
yes,
by the managing committee,
yes,
name is forwarded to the government.
yes, government for record purposes, not for the purpose of approval.
For the record purpose.
For record purpose, that is what is for record purposes and endorsement.
So there is this is an affidavit. Probably doesn't deal with the query of the court.
My lord, my lord, if your lordship give me some time, I will show why, my lord, here in the affidavit itself also contradiction is there, and I would humbly submit that there is a misleading statement before the Supreme Court, which your lordship may kindly take notice of it. Because this all affidavit has been filed by a responsible officer. After knowing lordship that the earlier affidavits filed by the joint DMC, therefore lordship insisted that it should be filed by a responsible officer. Now responsible has filed the affidavit, my lord, by swearing the affidavit. Now I will show how my lord, this is in consonance with. Now therefore, after the agreement reached by three parties, then the president or the secretary will issue. Now one of the point blank contention raised by my other respondent, number 7, is that my appointment letter was issued by the president of the SMC, not by the secretary. He was the secretary. So until unless the secretary recognized and issued the appointment letter, my appointment letter is wrong. So here the government affidavit say that even appointment letter can be issued by the president or secretary.
That one thing we do not understand, Mr. Shangareshu, that the statement that
yes,
the whatever this affidavit says, after which agreement is required to be signed by the candidate, school and the government represented by the DMC.
Yes.
What is the deputy mission coordinator?
Yes.
DMC is deputy
district mission coordinator.
Or the joint DMC.
Yes.
Thereafter, the president.
Yes.
Or the secretary. Yes. So ex officio member convener of the school managing committee.
Yes.
Issues appointment order.
Yes.
So there are three authorities.
Yes, three authorities need to sign in the contract agreement.
And what is ex officio member convener?
Ex officio, my lord, the secretary, they say the ex officio, they didn't spell out ex officio. Normally, my lord, the principal of the school becomes the ex officio in some of the cases, but they didn't spell out.
Ex officio member convener. Convener of what?
Convener of the SMC.
So that means that is probably during the time when the term of a previous managing committee expired, and the new managing committee is yet to be constituted.
Right. Now
is it at that stage? Is it?
My lord, here the headmaster or head teacher in the school normally becomes the secretary of the SMC, and he becomes the ex officio normally. But now here, admittedly, here it says that the president can issue or the secretary / ex officio. So three authorities are there.
Okay.
In my case, the president has issued the appointment letter, and because of that, the private respondent is disputing that my appointment is illegal because it is issued by the president, not by the secretary. So this is one clarification. And if we travel down by lot the para 5, that in the instant case, the deponent respectively submits that the petitioner is not the founder teacher in the Larmatis Ubisans rule. And when the petitioner was appointed as a science and mathematics teacher in the year 2014, no appointment could have been made without advertisement, and the same is not permissible. The normal procedure should have been adopted by the SSH school for appointment of teachers may be enumerated as under advertisement, constitution of interview board, conducting interview and selecting the suitable candidate following NCD norms, forwarding the name of the selected candidate to the competent authority for records and endorsement, signing of the 59 days contract agreement between the managing committee and teacher, issuing of appointment letter by the secretary. Now they change secretary. President is ousted. Ex officio member, convener of the managing committee, submission of joining report. Now A to my lord, A to F, A to E, none of the party, petitioner and the respondent of 7, fulfill this. In my case, no advertisement. Here's also no advertisement. Here's also no interview report. In my case, no interview report. No interview number C. Forwarding of the name to the competent authority for endorsement is not there for both the parties. Contract agreement not with me, not with him also. But issuing an appointment letter by the secretary. Now president is missing. In my case, prisoner issued appointment letter. In his case, secretary has issued the appointment letter. Now, in the instant case, while appointing the petitioner, none of the aforesaid norms and procedure were followed. Rather, the president of the SMC of the school whimsically fixed the whole process of appointment, perhaps for his own interest, for reason best known to him. Respondent number 7 was in the same position. It is pertinent to mention here that when the petitioner was appointed in the year 2014, NCT notifications and such was very much in force, and the same could not have been ignored. As per the said NCT notification 2021, the norms for appointment in the post of SSC upper primary teacher candidate should be now, my lord, these are the qualification, graduate ballot, and at the bottom end, the next page, teachers eligibility days. So both the parties, including me and the respondent number 7, do not have this qualification.
None of this.
None of this. Both of us.
Yes.
Both of us. My lord, therefore, the advertisement of the petitioner in para 7 of 3 of the writ petition that he was found to be qualified as per the SSA norms by such and such, and letter such is totally baseless and misleading. Therefore, said letter 2013 was issued in respect of the recruitment appointment of a teacher as per the NCT norms, wherein under point 2A, it is mentioned that the qualification for upper primary is PA, PSC, pass, and PET. And the letter relates renewal of the contract agreement appointment, and the same does not cover fresh appointment. Moreover, 45% criteria as stated in the letter that it's censored for SC and ST candidates and not for general candidates, and hence the same does not apply to the case of the petitioner. Now here, my lord, they have mentioned PSC, P8, my lord, PA, PSC, and P8. My lord, he has respondent number 7 also doesn't have. He is a BA, my lord, but no B8. I'm also not, I don't have a B8 also. Now, if we go down, my lord, a little bit further, my lord. Further, the petitioner could not have been selected without any advertisement or fair selection process by providing a clear, fair chance to all the aspiring candidates, which is against the standard practice and established procedure, and hence cannot be allowed. Apart from what is stated in above, the so-called appointment of the petitioner was clearly made by bypassing the head teacher, come ex officio member convener of the school. Who is that person? Number 7. He is the number 7 that time. The entire process was hijacked by the president to grant undue favor to the petitioner, and the same cannot be allowed. The petitioner could not have been picked up for appointment, knowing fully well that he failed in mathematics as well as he did not fulfill the NCT norms. From the record, it appears that the president of the SMC was at all in issuing the appointment letters and such, and also in accepting the supposed joining reports and such. And everything was kept secret and done behind the back of the head teacher, come ex officio member convener of the school, as well as from the education authority, and the same being illegal, be allowed or accepted. Secret, my lord, kept secret from the education authority is wrong. The approval also in my favor. Further, the subsequent approval orders and issued by the in charge joint GMC in favor of the petition also cannot be accepted as the same violates the above norms and procedure, as the government instruction in direction issued by the officers in 2013. Actually, the Joint District Mission Coordinator is not been mandated to accord approval to appointment of teachers under the SSA scheme, and as such, approval is in favor of the petitioner has no right to stand in the eye of law. Now, in that case, approval given by Joint DMC, not only to me, to the respondent 7 also. So both approval will go.
Now, one thing is that what surprises this court is that the affidavit comes from the government.
Yes.
That this appointment or approval given by joint DMC cannot be accepted.
Yes.
Now, this comes only after court asks them to file an affidavit. Now, before that, they remain silent. And the person concerned, whoever is appointed, irrespective whether you or he,
right,
they keep on getting their salary from the government.
Right.
And there is no objection to
that. Right. No
what kind of function is this?
And my lord, if lordship can see paras.
When a matter falls under legal scrutiny, then only they come up and they say, no, this was not correct. Had there been no query by the court, they would have continued. The position, same position would have continued.
Right.
And you go on appointing whomever you like and reject whomever you do dislike.
This is happening. And if my lord kindly see para 10, I may skip para 9. 9 also relevant, like, but for the time being, come to number para.
Now,
para 10.
what is the thing which will sum up from this affidavit? The state now says that both the appointments are not correct.
Now they still they say that my appointment is wrong, but his appointment is right.
They
Now
still
the
say.
reason, yes. Now para 10 will demonstrate. Well, Lordship kindly turn to para 10, page 11.
Regarding the status of respondent number 7.
Yes, that as far as the arrangement of respondent number 7 as headmaster come science teacher is concerned, it may be stated the same is not a fresh or new appointment as in the case of the petitioner. This arrangement reshuffling is an internal matter of the school management committee, and the same in respect for submission requires no interference. Further, respondent number 7 is a founder teacher and was working in the school from its origin in the year 2002, and thereafter when the school was brought under the SS scheme, he continued as a head teacher of the school. Allocation of subject to teacher is a prerogative of the SMC, the implementing agency, that is the state mission, education mission authority of the census, does not interfere in such a matter. It is further stated that the land in question, in which Lamati was initially started in the year 2002, was donated by the father of the respondent number 7, and subsequently the said school was shifted to another site, which was jointly purchased by respondent number 7 and 4 other teachers sometime in the year census. My lord may come to second paragraph, page 12, third paragraph, my lord, to save lordship. Further, the word further.
Just a minute. What is the name of respondent number 7?
7 is my lord. Mr.
Sam Sundaraya, my lord.
Yeah, Sundaraya.
So what?
And number para 3.
Just a second. See the last line. Last line of the paragraph 10.
Yes.
It is further stated that the land in which the Lalmati school was initially started in the 2002 was donated by the father of the respondent number 7.
Yes.
And subsequently the said school was shifted to another site,
yes,
which was jointly purchased by the respondent 7.
Right.
And 4 other teachers, sometimes in the year 2010. Right. Now, how 2010, how will land be bought by a non-indigenous person?
Therefore, my lord, the content of the affidavits, my lord, filed with the officer, responsible officer, it is purely they come out to favor the respondent number 7 without any basis. That is one fact lordship is not has
This will be hit by the land, Meghalaya transfer
Exactly.
of land regulation, isn't it?
Exactly. And donation of the land by his father doesn't carry any meaning. Because the abundant that want to shift to another place, purchase new
No,
one.
you see, like it's affidavit is coming from a government official, isn't it?
Direct admission.
It means government must have taken cognizance of the fact of transfer of land, or the fact of acquisition of land,
right,
by purchase by the
Right.
respondent number 7.
Yes.
Now, how can
7
this
and
be-
4 teachers, he said.
How
4
can that be
teachers.
held this thing? Now, we do not know, Mr. Sangresho. The problem is that here we are basically dealing with appointment.
Yes.
Teachers.
Well,
And now the affidavit is filed in such a way, it's taking us to somewhere else. Now, we do not know whether to basically come to a conclusion, whether some inquiry will be needed or not.
my lord, my lord, my lord. Therefore, my lord, if lordship will have bear with me and come to page 12.
Please continue. Sorry to
Third
disrupt you, but
paragraph.
then you basically
understand.
read it without saying anything. So suddenly it got the mind of the court. Anyway, please continue.
Well,
The next page.
then the next, madam. That page number 12, madam. But therefore, while summing up the matter, the second paragraph, the answering
You're skipping this paragraph that.
my lord, but just to save lordship time. But may I just go through, my lord? The SMC Lalmati is a UP school in series of meetings started from meetings as 2017 to 2017. Adopted several resolutions with regard to the subject matter of illegality of the petitioner's appointment. We have challenged all this, and were all brought to the notice of the Education Authority. Whereas the MC Resolution 2, 2014, supposedly appointing the petitioner was kept in hiding for 2 years, which clearly goes to show the fishy nature of such appointment and the unclean conduct of the petition in the whole process. Therefore, while summing up the matter, the answering should be respondent respectfully reiterates before this court that the SMC Resolution 2014 to appoint the petitioner, the appointment order dated such, an approval order 2016 issued after 2 years of issuance of appointment order of the petitioner is unacceptable and invalid on account of flouting about standard norms and procedure, with its qualification or the way the petition was picked up for appointment as well as the approval. Further, the appointment of respondent number 7 headmaster cum science and mathematics teacher is not a new or fresh appointment. It was an internal adjustment by the SMC, and most importantly, the respondent 7 had the requisite qualification for the post. My lord, hence for this internal arrangement, no approval is required. Now here it emphasizes, my lord, here it says number 7 has fulfilled the requisite qualification. What is his qualification fulfilling the norms of the NCT? But this affidavit has been filed by a responsible officer. They must have the, my lord, the conscience to disclose the reality. Admittedly, on the affidavit filed by all the parties, he himself considered that he did not fulfill. He did not fulfill the NCT norms. Number 7 himself said he did not have. And whereas the government officers that he fulfilled the norms. It's absolutely misleading, my lord, playing fraud with the court. And number 2, my lord, is not a fresh appointment, it is an internal arrangement. Where is the notification? Where is the policy taken by the government? We say that founding teacher can be made as an arrangement.
So, Mr. Sangraishu, the thing is that the matter is not only confined to the illegality in the appointment of respondent number 7. We are also dealing with the question whether your appointment is legal. Yes. Now the question comes, if your appointment is not legal, not valid,
yes,
then what right do you have to question? What is your locus?
My bad. Now, therefore, I challenge the appointment of respondent number 7. So if, my lord, I do not fulfill the norms, I don't indict it for appointment. And if the respondent number 7 also...
founding teacher, you are not a founding teacher.
That is true, my lord. I don't dispute. But where is the law? It says that the founding teacher can be arranged, can be adjusted. But it concerns with the education of the younger generation, my lord, may kindly see. No one disputed his founding position, my lord. But it ultimately, my lord...
This affidavit basically doesn't support your case.
It doesn't support my case. They are supporting the respondent number 7. Therefore, my humble submission is that
no, but the thing is that, only thing is that rightly or wrongly, your appointment was approved at some point of time.
Yes.
Now, what happens to those approval? Was it cancelled by the government?
No, nothing.
Except for raising doubt about those approval in the affidavit. Whether those approval were ever sought to be cancelled by any other high official?
No, not high. The same officer. Joint DMC issued the approval letter. Joint DMC has cancelled it. Joint DMC has given approval.
But your appointment,
yes,
otherwise was not cancelled, isn't it? Was it cancelled?
Which part, madam?
Your appointment, the approval of your appointment.
Yes.
Was cancelled.
It was cancelled by the Joint DMC, the same authority.
On what ground?
Saying that, my lord, I did not fulfill the norms. I failed in the mathematics, though it is not a requirement.
Against that, you have come before this.
We come here and we come to know that they have appointed the respondent number 7. Therefore, we also challenge the appointment number 7.
Was absorbed against the vacancy created by your ouster.
Yes.
Otherwise, he was there in the school.
Yes,
but then he was serving in a non-sanctioned post.
Or my lord, throughout from 2014, I was serving sanctioned post.
Just clarify the factual aspects without going to the legality of
yes, my lord.
This affidavit, since it was hard quite sometimes, this court doesn't remember. Now, so far, what could be gathered from this affidavit was that the respondent number 7 was there since 2002.
Yes.
As a founder teacher.
Yeah, as a founder teacher.
And he was continuing as such.
Yes.
Even at the time when you were taken into service.
Yes, yes.
After your ouster,
yes,
he was accommodated in your place.
Yes. Yes.
Correct?
Correct.
Now you are agreed by that, you have come out.
Right. Now, 2004, earlier, 4 teachers were there, including the respondent number 5, 7, as a headmaster. He was a headmaster and science teacher was resigned in 2014. So SMC has appointed me as a science teacher. There was no quorum. Now, at that point of the respondent number 7 was the secretary of the SMC. President was there. So president has, after adopting resolution in the SMC, appointment letter was issued. So he challenged that the appointment letter was not issued by the secretary, by him. So it is invalid. So salary was paid to me with the intervention of district mission coordinator. Then after my lord salary was paid, they stopped again. I filed a writ petition before this High Court. And during the pendency of the matter here before this court, they reached a compromise between me and the respondent number 7. And that compromise, internal compromise between them, say that from today onward, I will recognize you as a science teacher. You also withdraw the writ petition. Matter resolved there. He came back and withdrew. The writ petitioner came back and withdrew the writ petition. He did not appear in the agreement. The state was not involved in that agreement. Then later on, my lord, he received the salary again, 6, 7, 8 months. Thereafter, they stopped. At that time in 2017-18, he was pursuing science. Respondent number 7 is not a science teacher, a science student. He was a graduate. He was in arts. Now he pursued the science in open distance learning, my lord. He got it, and subsequently they adopted a resolution questioning my appointment. Then they removed me, and after I removed, he was appointed as a.
Where can I get where this court can get these facts at a glance?
I have given the compilation.
If I'm allowed to give only a small correction submission, my lord. My lord, what had happened, my lord, is that the appointment of the petitioner is not known to the school at all, my lord.
It's okay. It's okay. We'll come.
We'll come.
Number two, my lord.
Shutting you down. You will come. You will say. Let him finish. Let him finish. Sit down. Hold your question for some time.
Yes. Exactly. So the detail, my lord, list of documents chronologically, my lord, I have submitted.
The factual aspects.
Yeah, the factual aspects.
How many cases are there tagged together?
Two cases are there.
What is the other case about? 248 is about what?
The challenging the appointment of the respondent number 7.
That
and
is
the
for
first
salary,
one
my
is
lord.
first one is the withholding of the salaries.
Which one is 248 is the first one?
My lord, the first.
And 473 is the?
Yes. With regard to the withholding of the salaries.
248 is withholding.
Yes.
So basically that will merge with this.
Okay, it's a connected matter. So compilation has been made for these two writ petitions, my lord, and I have submitted the list of compilations. If Lordship may kindly see, we have submitted in the month of 22nd May 2024. At once, my lord, the Lordship has perused together.
That is what the problem is, that you say, like, if a matter is adjourned
yes,
on too many occasions,
right?
This should have been heard when this affidavit was filed. It was filed
right.
way back in October last year.
Right.
Now everything has gone out of the mind of the court.
Right. The state was unclear about their position. Therefore, we have given it wrong. Is it? In the month of May, my lord, before Lordship passed the elaborate order,
Lord,
we have submitted.
my apologies, my lord. The compilation
list
is.
of documents, my lord, we kindly see list of documents. First page you mentioned. List of documents. All the facts are mentioned.
Lord, my apologies. The compilation is not available with me today, my lord.
Just
Lord, it is also not available with me today, my lord.
Like last time when we submitted and Lordship has gone through together with the parties. We have given May I just assess the record? It is not. The factum of two cases are here, ma'am.
Here, your list of dates starts with 2010.
2010.
Doesn't go back to 2002.
My lord, that was not the issue. Therefore, it started from 2010. My lord, we start from page 1. The genesis of the crisis faced by the parties here today.
Okay, you just arrange these documents.
Yes, chronologically.
Okay.
My lord, this 2010 was the appointment, my lord. As recommendation by the managing committee of
Respondent number 7.
Yes.
Of the appointment of respondent number 7.
Number 7.
Yes.
Number 7. He was appointed. Thereafter, 2019, we filed a petition, my lord. Thereafter, my lord, page number 2.
Yes.
This is the MC resolution adopted on 25th April 2014. Now, my lord, may kindly see page number 3.
Yes.
Here, Mr. Shri Habatu Raman, science teacher, was resigned. Therefore, SMC consciously appointed the petitioner in his place.
But then admittedly without any selection process, without any advice.
Yes. I do it. And thereafter, page number 4. Appointment letter was issued by the president. Here, number 7 say that issued by the secretary. Now, the state affidavit say that the president can
That
issue.
is your appointment.
My appointment letter. And page number 5. There was a direction by distribution coordinator to look into the salary of the petitioner. He was serving there. Salary was denied. And thereafter, page number 6. The respondent number 7 himself has written this letter to the distribution coordinator. And in the middle of the page, my lord, name of the teachers, Sri Shyam Sundar Rai, PA, past headmaster. He never claimed as a science teacher. He has written this in 2015. Lordship, in the middle of the letter.
Yes.
My lord, he was yet to be born as a science teacher. He was only, he admitted himself he is a headmaster. Now, thereafter, page number 8. The TMC has clarified that the sanction post has been clarified by the TMC in the SSA school. With the headmaster, there is no post for headmaster under the SSA scheme. And thereafter, my lord, page number 9. In view of the, my lord.
When this school was brought under the SSA?
This prior to 2014, before the induction of the petitioner.
And then when the school is brought under SSA, what happens to the existing school teachers?
Existing school teachers. They ought to fulfill the norms and face the appointment. But the policy never says that it should be adjusted. So my humble respect of
policy
submission.
Is silent with regard to the existing.
Completely silent. If the state government today produce a policy paper that the existing teacher can be adjusted, I have no case.
Where is the policy? Have you any?
Nothing.
The SSA policy is here.
My lord, it is not there.
Is it available? It is not available on record.
It is not available online. They don't produce.
You hold a copy of this thing SSA.
Only what we have is RT. The RT Act.
No. What about this?
My lord, from time to time, executive instructions, my lord. Our SSA, specific SSA rules, my lord.
There may not be a rule. There must be. The scheme may say that which men are the teachers to be appointed, or what would happen to the teachers, those who are there at the time the school is taken under the scheme. The school is brought under the scheme.
But this is what the affidavit says, that normally what happens with the founding teachers.
What does it say?
But here in para 10, I may be allowed.
This is your last affidavit. Which,
yes.
What does it say?
Well, it says that as far as the arrangement of, that is the respond, here of course it is respond number 7 at headmaster cum science teacher.
Yes.
It may be stated that the same is not a fresh or new appointment as in case of the petitioner. This arrangement shuffling is an internal matter of the school managing committee, and the same in respectful submission requires no interference. Here, my lord, further, the respondent number 7 is a founder teacher and was working in the
But
school.
then it doesn't say anything about the SSA. It says it's the internal matter between the management and the school.
My lord,
We are
no,
talking-
management
we are
is
looking- we are-
regarding
we are-
the SSA school.
We are looking for legality, not the factual things.
My lord.
Now, normally this court would normal. What this court would like to know is that normally, whenever a school is taken over,
Well, because my
okay,
lord,
or it is brought under the scheme, then what would happen to the existing teachers?
my lord, what with due respect, my lord, what we have, because we have dealt with quite a few cases, my lord. The founder teachers, it has been found that they remain in the school, my lord. This is not
No, but
just
then
one case.
Is it like on like? Is there any provision in the scheme itself to deal with that?
Well, that specific, my lord, then I'll have to seek specific instructions.
Because this
my
may
lord.
become relevant
My lord.
since your affidavit is supporting the appointment of son number 7.
Yes, my lord.
On certain grounds, whatever you say. So whether that can be held legally valid or not,
So, my lord,
for
for that,
asserting that, we may have to go through the scheme.
my lord, then that respect, my lord, kindly allow me some time. I will try to seek specific.
Anyway,
instructions.
just let us see, Mr. What Mr.
Well,
Sangresh says. We are at page 8.
Page number 8, madam.
Yes, we are compiling this.
Because the SS scheme melodies are sponsored by the central government, therefore the post also identified. And page number 9,
Yes.
my lord, the TMC again written this letter, my lord, the last paragraph.
Yes.
But therefore requested to expedite the process and submit action taken report on the above matter to the office of the undersigned without fail, and also you are requested to submit a copy of the approval order of teachers of Larmati. So approval order was sought. Later on by page
Approval
number.
order of whom? What
Approval of the
approval?
teachers of the appointed in the Larmati school. All the approvals of the teachers in the Larmati school. In my school.
Approval for all the teachers.
Yes. And my lord, my approval is page number 10. My lord, here it says hereby provisionally approved.
Yes.
My lord, provisionally approved by Sri Hamadur Rahman science teacher resign. So my appointment was in view of the resignation tendered by the Mr. Rahman. So this was the approval, provisional approval, 2016. And my lord, page number 11, the district missioner coordinator directed for release of the salary in my favor. So the affidavit filed by the state officer that my appointment was without the knowledge of the government is absolutely wrong. I would never expect the senior officer to make this type of statement before this court. The joint TMC
Page
also.
10 also is this thing by their officer only.
Exactly,
Joint Mission
the
Director.
officer only. The officer.
Page 10 and 11.
Exactly. They would
Does
say
it amount to misleading the court?
that amounts to misleading the court, my lord. Exactly. Therefore, I will humbly submit that this cannot be expected from the senior officer. So, in order to lordship to reach an authority pronouncement, lordship insists the government to file an affidavit by responsible officer. And responsible officer is supposed to file with full of commitment. This is and page number 11, page number 12.
This is not very appreciable thing if your officer says so that it was done behind your back. Because these are the documents. You are not disputing that document.
My lord, the same appointment order was also cancelled.
But then to say something that it was
My
done
lord,
without your knowledge.
My lord, this has happened in the district level, my lord. The directorate is not aware of this.
So can a superior officer of a state escape by saying so?
My lord,
because this court, when it passed an order directing
my lord,
the
will
superior officer to file an affidavit, please listen. Okay. What happened? You see, this was done only after this court had gone through these documents.
Yes.
So even if this skipped his knowledge at that point, relevant point of time, it was very much on record when he filed the affidavit. So he should have dealt with this.
My lord will kindly appreciate. What had happened is that there is a written instruction from the department, my lord, from the office of the state project director, from the office of the directorate, my lord. where there is a clear bar, my lord, for appointment, any appointment orders to be issued by. Yes, yes, my lord. There is a.
Oh, sorry, joint mission there.
Joint or district mission. There is a standing instruction from the government itself. So the fact that this order was issued was not within the knowledge, my lord.
You can
my lord.
understand. Maybe it had happened that point of time. But at the time when this affidavit is filed, in October last year, these documents were very much a part of record. Was it not required for the officer to take
My lord,
cognizance of
these
this?
were
And then
as well as the standing instruction, my lord. That is also part of the record, my lord. This was brought on record by this affidavit.
see, your affidavit says that it was not within your knowledge.
My lord, when the appointment was made, my lord.
Now, if you say within your knowledge, do you mean your personal knowledge or knowledge of the department?
Knowledge of the department, my lord. At the time when the appointment was
So your officer is a part of the department. We do not know if required. Will see. This is all along. This court was,
my lord,
avoiding. You see, like
my lord may
those kind
kindly
of-
appreciate. Here is a case, my lord. Petitioner has to stand on his own footing, my lord. He cannot depend on someone else.
We can understand so far as the legal aspect is concerned. You may be right to some extent. Yes, definitely. He cannot come. And you see, like basically may succeed on the basis of the weakness of the respondents. But then here things are not confined to that. It has gone bit beyond. What happened after hearing the matter at some length? The responsible officer of the state was asked to file an affidavit clarifying certain queries of the court. Now he does it, but then he makes certain statement where he says that the appointment of the petitioner was not within the knowledge. Now, if he, within his knowledge, now if you see these letters, those letters were issued in 2016.
My lord.
Okay, and some responsible officers approved the appointment.
My lord,
And
on
then-
the district level. my lord.
Yes. Now, is it that the district level is some independent authority? They're not independent authority, isn't it? You being head of it, they are under you. So you have to take
My lord,
responsibility.
whether
for
any
those.
copy is marked to the government, because I do not have a copy.
This is part of my writ petition, and we have
My
some
lord,
copy also. It
These,
is
as
in
I
the writ
earlier
petition.
stated, my lord, I do not have this with me today.
It is in the writ petition. If my friend has a writ petition, it must be there.
My lord will kindly appreciate the facts of the case, my lord. Fact is here, my lord, in 2014.
See, this court may not give relief at the end of the issue
My lord.
to this petition. But then you being state official,
My lord, what I have
you must
stated, my
come
lord.
clean. You see,
So, my
that is
lord,
what-
with due respect, my lord, what I have stated before this honorable court, my lord, is as per the facts and circumstances that were known to me at that relevant point of time, my lord. Now, my lord will kindly appreciate, here is a case where the petitioner.
see, Mr. Bhattacharya, before you proceed further with your submission, just take note of one thing. The officer who has filed this affidavit, he was not holding that rank probably in 2016.
Yes.
Isn't it?
Exactly.
So that way, definitely, so far as personal knowledge is concerned, is relief from that. But then when he takes up the position, when he assumes that charge, and when he is asked to file some affidavit relating to an incident of 2016, then it is expected that he goes to the records and file an affidavit. Now here, probably he has not done that. Okay. Now, if he
My lord, will
says,
kindly see
that is why this, one second, just hold on.
My lord.
That is why this court had asked you that when you say that it was not within your knowledge, do you mean your personal knowledge or knowledge of the department?
Even the department, because no copy is marked to the department.
So
My lord
once-
will kindly see from that letter.
No, it is okay. Department means this district, joint district mission also. It's a department, it's a part of the department.
Then part of the department, of course, the district mission coordinator is aware, my lord.
Yes. And come to the letter at page 11.
I do not have this with me today, my lord, as I had earlier
You
stated.
can just have a look from Mr. Sangreshu's. He will be kind enough to hand it over to you. Come to page 11. Come to the bottom. See the copy 2.
Here, my lord, State Project Director.
Yes. So now your affidavit basically is totally wrong. You can hold it now. There is no confusion. This is a problem, you know.
Personal knowledge, my lord.
Then you are inviting your own trouble then. We do not know. We'll just
Because I do not have this with today, my
it's
lord.
okay, no problem.
So
We
my
cannot pass an order today, but then
kindly,
you take notice of all those things.
my lord, I'll look into all that. My lord.
This is not very pleasant.
I'll look into all that, my lord.
Mr. Bhattacharya, education department is one department. When you handle a case, please remain calm. Do not just become a mouthpiece of the department.
My lord.
Your duty basically is to place the correct thing before the court.
Yes.
It is more than defending your client. You should protect the interest of your client, but at the same time, please ensure that only the true and correct materials you place before them. Your responsibility is more there in this
Yes.
aspect. Kindly, that is what to be remembered.
My lord.
We also do not know, Mr. Sangreshu, what end result will come, whether that he will be getting an order at your favor or not. But then these are the situation which is quite disturbing.
Well, I may lose the writ petition, but the law is very clear, man. Either petitioner or respondent, he who comes with this honorable court must come with a clean hand.
My lord,
That is the basic tenets of law.
petitioner has not approached this honorable court with clean hands.
Let my friend Argu point out.
My lord, the fact, but only if I am allowed to rely on the fact, my lord. Some appointment is made in the 2014, my lord, that the school regular managing committee is not aware. The petitioner never, my lord, never attends any class, never goes to the school. Suddenly he files a claim for salary, my lord. The attendance register, which is there on record, will show, my lord, he never attended the school.
It's all right.
But he is claiming salary.
It's all right. It's all right. But then we cannot travel to all those things.
My lord, because that is the fact of his case.
Mr. Bhattacharya, you see, but Kunya quite senior in this, like you know, like where we right now we are not dealing with all those things. It is not that you have terminated service because of misconduct on his part, because of his unauthorized absence in the school, isn't it? It's a termination simpliciter.
He never went to school.
Terminated stigma, isn't it?
He never went to school.
Where is the question of going into all those issues? This probably raising those will not help you. Please appreciate this. We are confined with the issue of the eligibility of the petitioner as well as the respondent number 7, and also the legality of their. But that is what. Now, probably you see, like this court had asked for an affidavit to be filed by a superior officer because of the fact that the court was confused. That how could you see like a person's appointment be approved, and then again you see like that will be cancelled, and then another person who already was in service will be absorbed in that position. Okay, and there are some communication which specifically bars a specific authority to accord any approval, but in spite of that, that officer goes on giving approval, and your department is silent, and now you file an affidavit before a court saying that you have no knowledge of that. Now, can a head of the department escape his liability, his responsibility by saying so? And when these letters specifically show that these were forwarded, and even in absence of that also.
My lord, if I am allowed to refer to para 6, my lord, of my affidavit.
Of your affidavit?
Yes.
The latest affidavit?
Latest affidavit, my lord. My lord, if I am allowed to read from para page 3, my lord. Page 6, my lord. Page 6 from therefore, my lord, if I am allowed to read.
Page 6 from?
Of my
Therefore,
affidavit, my
yes.
lord.
Therefore?
Yes, my lord.
Yes.
Therefore, the averment of the petitioner in para 3 of the writ petition that he was found to be qualified as per SSA norms. This is regarding his qualification, my lord. Provide letter dated 23/2013 and letter dated 21/3/2013 is totally baseless and misleading. The aforesaid letter dated 23 2013 was issued in respect of recruitment, appointment of teachers as per NCT norms, wherein under point 2A it is mentioned that the qualification of UPA upper primary schools is BSc. This is what the letter content of the letter, BA, BSc passed and BEd, that is B.Ed special education, and that the letter dated 21/3/2013 relates to renewal of contract of appointment, and the same does not cover fresh recruitment. This is what the letter said. Moreover, the 45% criteria stated in the letter dated 21/3/2013 are for SC and ST candidates and not for general candidates, and hence the same does not apply to the case of the petitioner. Further, the petitioner could not have been, so this is regarding his selection, my lord. I will take my lord to.
Now you show us what you are trying to point out.
My lord, the clarification, my lord.
You are doing random reading without knowing what you want to point out.
My lord, further, the petitioner could not have been selected without any advertisement or a fair selection process by providing a fair chance to all the aspiring candidates, which is against the standard practice and established procedure and hence cannot be allowed. Apart from what is stated here and above, it is the so-called appointment of the petitioner was clearly made by bypassing the head teacher come ex officio member. My lord, he has to be there, my lord. Ex officio member, convener of the school managing committee. The entire process was hijacked by the president to grant undue favor to the petitioner, and the same cannot be allowed. The petitioner could not have been picked up for appointment, knowing fully well that he failed in mathematics as well as he did not fulfill the NCT norms. This is pertaining to qualification, my lord. From the record, it appears that the president of the SMC was all in all in issuing the appointment or letter dated 22/5/2014 and also in accepting the supposed joining report, my lord. This was also accepted by president himself, my lord. And everything was kept a secret and done behind the back of the head.
Address the court on those approval. We have seen it. Mr. Sangresho basically
My lord,
has
para
taken
6, my lord. The para 6 down below. The claim of the petitioner that he was serving in Lalmati SSA Upper Primary School is also false and baseless, as school attendance register speaks otherwise, as his name is not reflected in the attendance register and UDICE database of teachers of Lalmati SSA UP Salsala block, Annexure E of the affidavit of the school. Copy of the database with effect from 2009 to 2023 is enclosed herewith as Annexure E. This is a database which is there, my lord, at Annexure E. There is no whisper of petitioner anywhere, my lord.
No, how do you deal with those letters?
Page 23.
How do you deal with those letters? We are on specifically into this at this moment. Mr. Sangresh, where is your termination letter?
My termination letter, my lord.
In that compilation?
Yes.
In this compilation?
My lord. Page number 34 in that compilation. It says that as per School Managing Committee Resolution number 1, 5th December 2017 of the Lama DUP School, the approval order of Sri Islam by such and such since 2016 here is then cancelled. It is found in records that the appointment of the National Islam is not done with it.
No, where is that resolution then?
Well, that resolution would be available in page number 30. 30 of the very compilation Lordship is holding.
Yes.
Well, yes, it's the SMC meeting of the Larmouth UP is held today, 5th December 2014, to 17, such. Now,
what is the part by which you were?
my lord, we come to page 31.
31, yes.
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 It is noted and found that one of the founder and senior most teacher having the SSLC science qualification. So the School Managing Committee of the UP School unanimously appointed Mr. Sundar Rai, SSLC Science PA pass, as headmaster, come science and mathematics teacher in the said school, and the question of additional teacher science does not arise because the government is not recorded any sanction for the additional teacher. But it is worthy to mention in this meeting that the then president, for his selfish gain, appointed Mr. Islam as a science teacher who has no requisite qualification as per norms because he has failed in mathematics in the HSLC examination and also without the knowledge and concern of the headmaster cum secretary, as well as without any advertisement or approval from the authority concerned, and even Islam did not join in the school in due course of time, and the incumbent Mr. Islam on misleading the then STSU.
So it doesn't say about this unauthorized absence or not absent for duties and all those things.
Nothing.
The termination is because the earlier president wanted to appoint you.
Yes.
And that was done without following any process of it.
Yes. Without his knowledge.
Yes.
Ex officio.
Without advertisement, without approval from the authority concerned.
Yes. Yes.
Yes. Now that is what is. Now, basically, Mr. Kapi Bhattacharya is trying to take us on some different thing.
My lord, will kindly see for our, there is no specific denial, my lord. This is what we have stated regarding the petitioner's appointment.
No, but then what we have
there
to
is
do
no
with
denial, my
those part? If it is accepted also, what we have to do it? Because you see, his termination is not on those. You are trying to basically dodge the issue.
My lord, if his appointment...
What you are asking, our question is confined to that how come an affidavit be filed? Pleading ignorance of a fact, which apparently, you see, like your officer had part. Now, is it very correct thing to do?
My lord, my humble apologies, but my lord, will kindly see, my lord, there is no specific denial on our part, my lord.
Which
only said that, only we said that appointment order was incorrect. That is what we have stated, my lord.
We are not on that issue, you see. We do not know whether we have been able to communicate it to you or not. In your affidavit, you say the appointment of petitioner was not known to you. But then your officer approved it.
My lord, if I am allowed to read the line again, my lord.
Which line?
Kindly. Appointment letter, my lord. This is para 6 only, where what we have stated, my lord, in this affidavit.
Yes.
My lord, from the record,
which part you already reading?
My lord, again I'll take my lord to page 6, my lord, end of the paragraph, my lord. From the record it appears, if I'm allowed to read. Page 6, my lord. Ending.
Yes, from the record it appears.
Appears that the president of the SMC was all in all in issuing the advertisement appointment letter, so and so, and also in accepting, suppose joining report dated so and so, and everything was kept in secret and done behind the back of the headmaster come ex officio member convener of the school as well as the education authority. My lord, what I am trying to impress upon this honorable court, my lord, it is talking about the appointment which is given by the president. My lord.
But then what the court wants your response is with regard to those letters, which Mr. Sangresho has pointed out. Now, this paragraph doesn't specifically deal with all those things.
My lord, this deals only with the president, appointment order being issued by the president.
It's all right.
And
what about now? Our query is confined to the.
Now, as far as the approval order by the department, my lord, in the next line we have stated,
Yes,
my lord,
yes, yes,
for the subsequent order of approval dated 22/6/2016,
Yes.
issued by the then in charge joint DMC in favor of the petitioner also cannot be accepted. We have not denied anything, my lord. What we have stated, cannot be accepted as the same violates the above state norms and procedures as well as government instruction direction issued by the office.
Yes.
So, my lord, the denial that we are stating, my lord, without the knowledge, my lord, that is the appointment which is given by the president, my lord, and the approval order and the joining letter accepted by the president. That we have no knowledge, my lord. That is what we have stated. About the letter, my lord, there is no denial. We are saying that it could not have been issued.
So it is not a case that you do not have no knowledge of that.
My lord.
What you say that this is not valid in law.
Exactly, my lord. Because here the specific word is the appointment letter issued by and the joining letter. Because why did the petitioner have to submit joining letter to the president, my lord? What was his business? He should have submitted to the school. If his appointment is genuine, my lord, assuming that his appointment is genuine, what prevented him from submitting the joining letter to the school? Why to the president, my lord?
President represents the school, isn't it?
My lord, school, he is the teacher of the school.
There, without addressing any officer, there cannot be a letter
So,
to
my
the
lord,
school.
there he has to show some evidence also, my lord, that this is my name. This is my name as a teacher in the register. I am attending school every day. This is my signature.
Then on what basis those letters were issued then? Those letters at page 10
Yes,
and
definitely.
11 of the
Those letters
compilation.
are mistake, my lord.
It was mistake.
It could
One
not have
mistake,
been
the
mistake,
second
my lord.
mistake. And that mistake remains so long the court asks you to pass file an affidavit, isn't it?
My lord,
Page
his-
11 basically footnote says that it was forwarded to you.
My lord, if a teacher is serving in a school, my lord, basic thing is his register, my lord. Attendance register.
Then what your officers are doing? What these officers are doing, just say who additional deputy commissioner come district mission coordinator. Where he works and what basis he signs these orders.
That is definitely a mistake, my lord.
And you remain mum. You initiate no action against these officers. You are granting them protection to do all those things. This has become, do not know which way things are going on. You see, it's a total kind of anarchy, you see, like whoever comes to power, he does whatever he wants. and they escape with the situation. The public functionaries. And do you propose any action against a person who violates that standing norms?
My lord, off record, my lord, if I'm allowed to submit, my lord, to my knowledge, my lord, some action is already initiated against one of the officers. But of course, this is off record, my lord. I'm
We
not
can
sure whether
understand,
it
but
is
then,
related to this case.
see, these are happenings on a regular basis. You are playing with the lives of people, their career. You go on appointing anyone you want, you allow them to continue for some period of time, and then something happens, somebody else comes in your position, then he is not happy with them, he discontinue, would appoint another one. You know, what is this? And then you being superior officer, you keep mum. And you just come and say that this is illegal, this cannot be accepted.
My lord, even assuming, let's assume for argument's sake, my lord, that everything is genuine. Let's not, even if we don't dispute that, my lord. But my lord will kindly see the qualification. On that ground itself, the petition goes.
Accepted. Let us say that he has no authority. But then how do your officer approves it? Let us say that he doesn't have qualification. Then how your officer approves it? Further, his claim of non-payment of salary also is taken up. A direction is passed for payment of his salaries.
Because, my lord, the petitioner misled the honorable court.
Who? Your officers?
My lord, the petitioner.
No, we're talking about those letters. And this court still wonders how you deal with your officers who keeps on doing this kind of things. Issues approval when knowing very well that he is not authorized. You being superior, you say that he is not authorized, but then you take no action because of issuance of this. You take no action if in case he gives approval. Now, what kind of administration is this? Of course, these things doesn't add to the petitioner's case. It would not add to the merits of the petitioner's case. But then what about you? It is your indulgence which makes these things possible.
I understand, my lord.
Where is the scheme? Can you get us a copy of the scheme?
Scheme, I'll have to inquire from the department, my lord. Perhaps these are instructions issued.
Anglisha, do you have a whole scheme of that thing?
It seems that there is no specific hard copy of scheme, but it is governed by executive instruction issued by the government from time to time. And in the affidavit, they have an extra last page. It seems this is the guiding principle for
last page of
the latest affidavit filed by my friend.
At
my lord,
page.
My lord may start from page number 24, 24 and 25.
Yes.
Yes. Though it is a prospective in nature. 24, anything.
This is the latest standing instruction of the government, my lord.
My lord, office order 17 December.
Yes.
It is hereby notified that the vacant posts of assistant teachers in SSA, LP, UP, schools caused by retirement, decease, resignation, etc. shall not be filled up without approval of the Office of the State Education Mission Authority of Meghalaya, Government of Meghalaya. In case of appointment made without the approval of the competent authority, the post shall be considered as a desanction and financial support shall be terminated. This is one.
Is it 2007?
These are the latest
2020.
And another one, last page.
Yes.
And the last one is issued by the state government, where the project director is supposed to follow this direction. But his affidavit is different again. I'll go through the content there.
My lord will kindly see, this is
Let
regarding
me
current
just-
appointments
let us just
that we have
straight
stated in our
straight out this.
affidavit. My friend is
Let me
misleading
just
this
straight out
wonderful
this.
document.
Let me just straight out this.
Talking together will not serve any purpose. Which this is page?
Page, the last page, 25, my lord.
Yes.
3rd September 2021, is issued by the government. Appointment of teachers in SSLP UP school in the state. In pursuance of this office members and such, I want to state that various letters in the proposal has been received in the state office, Shillong, related with approval for appointment of teachers in SSA schools directly from the school authority and office of the district mission coordinator SSA without following the norms and procedure. Henceforth, it is hereby directed that all proposal for obtaining approval for appointment of teachers in SSA school, both LPS and UPS, should be submitted to this office after the following procedure is indicated below. Number 1. When the post of assistant teachers in SSA, LP, UPS falls vacant due to resignation, expiry, retirement, etc., the managing committee of the school concerned should inform the TMC of the district concerned. The enrollment of the students in the school, the number of the sanctioned posts shall be clearly indicated with a request for permission to advertise the posts. The DMC is concerned shall scrutinize the pupil teacher ratio of the school and if eligible shall recommend the name to the SPO for approval. After approval from the SPO has been accorded, district mission coordinator concerned shall inform the school authority to advertise the vacant posts.
Who is SPO, Mr. Ramesh? SPO
State project officer, madam.
State project officer.
State project officer. Vacant posts and conduct the interview. Only candidates fulfilling the NCD norms shall be allowed to attend the interview. After conducting the interview, school managing committee shall submit score sheet duly signed by all the interview board members, the list of qualified candidates in order of merits to the office of the district mission coordinator for scrutiny and further necessary action. The district mission coordinator, joint DMC concerned shall submit the recommendation of the government concerned to the state office for approval. The above procedure should be strictly followed by all concerned with immediate effect, failing which no approval will be entertained. This information and further necessary actions. But clearly, my lord, where is the provisions, guiding principle where founding teachers can be adjusted? Nothing.
That is the 2021.
Yes. Madam.
Now the time when the scheme came.
Yes.
The scheme originally formulated.
Right.
And it was applied.
Right.
Then definitely what happened to those teachers?
So in those, in my humble submission, any candidates who has a secondary school are eligible to become a teacher. Therefore, he was appointed. SSA came also arising from the RTE 2009. Subsequently, for implementing the RTE, central government has introduced this SSA scheme to sponsor the primary education, in upper primary education in the entire country. So in fact, SSA scheme is a financial grant by the central government with a certain rider of qualifications and the appointment process. At that point of time, my lord, he was eligible. Therefore, nobody raised this. So I would surrender, my lord.
That is okay. But then the thing is that what is the law in this?
My lord. Therefore, I was eligible. I would, my lord, sit down and concede if the state produce any guidelines.
No, you see, it is so far as you are concerned is okay. You are concerned. What we want to know is with regard to your challenge to the appointment of Respondent number 7. Now, what happens to the status of a person who is already serving this school after the school is taken over under the SS, or it is taken under this scheme? So included, brought under the scheme. Then what happens to the existing teachers?
The existing teachers, my lord, when we see the NCD norms, serving teachers also required to fulfill the norms.
This norms must be saying something. Yes, who is
the norms of
number 7?
Mr.
Yes, what is how your appointment is protected when the school is brought under SSA?
So you look as per notification, this NCT norms is not applicable to.
No. What we want to know is that since you were there as a school, as a founding teacher, before it was included, it is brought under SSA. Whether your appointment basically automatically regularized under this. Is it? Where is that law? Where is that? Where is that? Just show us something.
Here, this NCT norm has come out. My comparison case.
Yes, Mr. Devnath, we'll come back. We'll resume after the lunch break. We'll resume after the lunch break.
May please, Your Lordship. Your
Yes.
Lordship, I beg to submit item number 29, my lord. My lord, if my lord pleases, next week.
Yes,
Yes, Mr. Yuvin.
My lord, I have little objections to that, my lord. Minaris, that's a lady who has been in jail, my lord. So this is an appeal from the jail, my lord. So already 3-4 adjournments. If I've
Next
subject to
week we'll do it,
corrections.
my lord. Today, due to personal difficulties, senior counsel had to go. So I'm
And,
praying if
she has a small daughter who is also not keeping well, my lord. So
Yes.
the outcome, whatever may be the outcome, but that opportunity of
day after tomorrow in that case, my lord.
day after tomorrow, my lord.
Yes, Mr. Shula, you are there. This-
No.
Lordship, in item 25, that is linked with this Minaris Moli, no?
No, no,
Not Minaris Moli?
You are
Yes.
Minaris.
Oh, the other one, yes, the other one. Yes.
Item 25?
25, yes.
Common, same judgment, Your Lordship.
Other co-accuser.
So you are ready with the matter.
Next week, my lord, I was praying.
In 25 also you are there, Mr. Shula.
In 25, I'm there, Your Lordship.
29 also you are there.
No, 29, I am in
is by,
circle.
Mr. Khalid Khan. That is subsequent. It was filed subsequently, Your Lordship.
But arising out of the same judgment.
Okay, day after tomorrow then.
Day after tomorrow, my lord.
So
Day after tomorrow, it's a holiday.
Oh.
After a week, my lord.
After a week means because next week though, there's lots of holidays. Then comes
Very
after 2
difficult.
weeks.
No.
Friday is if
Friday is very uncertain, Mr.
Then 16. Take a chance on 16.
Yes.
On 16th, we can try.
Anyway, just say after a week. Let us
After
come
a
back.
week, my lord. Any
Just say,
day, after a week.
just say the request made on behalf of the state correspondence. This is matter after a week.
That is item number.
Up to this is 29 only.
29.
So 25 will be taken up.
25, 29.
Yes.
Same. In 25 also same order.
Lordship, there is an item number 20. If this matter can be taken up after a week, Your Lordship.
28.
28.
With the other side.
My lord, I am there, my lord.
Item 20.
28, Your Lordship.
28.
Any problem?
No, my lord.
28 just after 2 weeks of the request made.
Lordship, I am highly obliged, Your Lordship.
We have the state. You write it properly? Yes. Yes.
Your Lordship, I beg to mention item number 21. Your Lordship, due to some emergency, the conducting counsel, Mr. Sen, had to leave. So this matter may be taken up after 2 weeks, Your Lordship.
You are appearing for the?
For the petitioner, Your Lordship, on behalf of Mr. Sen.
Lordship, no objection, Lordship.
After 2 weeks of the request made on behalf of the petition. Yes.
Highly obliged, Your Lordship.
Lordship, may I go, last question I have given compilation. If compilation it be easier.
It's submitted a compilation.
Yes, Your Lordship. So, Your Lordship, here.
Just a minute. Here to find out. What's the compilation? Yes.
So, Your Lordship, here I'll be giving little bit details about it. Some details I am trying to go. So, Your Lordship, here in page 25. Page 25.
Yes.
So, this is the notification.
Yes.
By the Minister of Law Justice, and this is the Constitution Amendment, 86 Amendment Act of 2002, and this 12 December 2002, which Your Lordship, last edition my learned senior friend has pointed out that as per this notification, NCT norm is applicable to the.
Where is that part?
So, Your Lordship, this is the Constitution Amendment schedule,
Yes.
and this is the given. This state shall endeavor to provide the children the care and educations to all children until they are completed age of 16 years. So this is the method. First of all, he's argued on the basis of it. Then the respondent number 7, his appointment to do, and he's required to be follow the NCT norm. Because of it, these notifications come into force. So
No,
this is not.
What it is specific for it? It doesn't say about anything about appointment.
So it is doesn't, but this is the notification when it is come under the Constitution Amendment
No,
about
see,
the children.
yes, the right to education.
Right to education
Yes.
come. So this is the point he was raised in the first question when after this court is digging so many meters. So that's why I brought this notification copy. So you'll see I'm coming one by one because I'm trying to just because it, and thereafter you'll see our school has come into under the government in 2000 sometime in 2004, and it is given effect 2003. This is the page 27.
There is no separate order passed bringing the school under this scheme.
You'll see I'm coming later. So I'm saying this due to this you'll see appointment road respondent number 7 was in 2002, and subsequently government has taken into consideration this school as a aided school. So here prior to this respondent number 7 was appointed. So when this government is taken subsequently, so where's the appointment given to respondent number 7 prior to this, so he cannot challenge, even petitioner cannot challenge about the appointment of the petitioner. Because of it, he was earlier appointed prior to this, even government is taken into consideration of the school. So this is one of the argument of mine. So now you will see if we come to this SSA. Page number 30, you will see.
Just a minute, just a minute. Who is appearing for the managing committee?
You will see myself.
So you are not only respondent number 7, you are respondent number
5, 6. I've given this 5, 6, and 7. So you will see here, page 30.
Yes.
If we consider about the RTA Act, then RTA Act is coming to force as per the notification of the government of Meghalaya.
Page
This
30.
Page 30.
Yes.
Recruitment, subject is recruitment appointment of teacher as per any NCTE norms. This is the subject. This is given. So, as you are aware of the NCTE norms coming to effect from 23rd August 2010, where it has been specified that only those teachers fulfilling the NCTE norms should be considered for appointment in the primary and upper primary school. This is applicable to all category school, whether it is government, private, aided, or unaided school. In these connections, you are requested to issue the instructions to all non-government school to recommend only those teachers who fulfill the NCT norms in the qualification. So, Your Lordship, if any qualification is required and it is coming to force from 23rd August 2010 as given the notification by 30th March 2011.
Yes.
So, in view of this notification, Your Lordship, this respondent number 7 was not required to have the norms of NCT when he was got appointed.
So this requirement will not bind him.
Yes, sir. So here, let's see, then subsequent notification page 31.
Yes.
So you will see last question I just said page 25, the Constitution's 86 amendment. So it is referred here. This page 31. May I read, Your Lordship?
Yes, yes, please.
In excess of the power conferred by subsection 2 of section 1 of the Constitution 86 Amendment Act 2002, the central government hereby appoint the first day of April 2010 as the date on which the provision of said act shall come into force.
Yes.
So you will see here, the central government has notified, though constitution amendment was there in 2002, but it will be effective with effect 1st of April 2010. So prior to this, so accordingly, in subsequently page 32.
That is, all these are regarding right to education.
Right to education. So you will see here, as because I am under now right to education, so it is required because appointment and others is
You've taken all those stand in your affidavit.
Yes. So in excess the power conferred in subsection 3 of section 1, right to education, free compulsory education act 2009, 35 of 2009, the central government hereby appoint 1st of April 2010 as the date in which the provision of the act has come into force. So it is clear that when this notification has come into force, RTA, and what still applicable here. Then velocity does come into play. When this notification is given and for academic purpose, what should be the conditions? Page 33.
Yes.
So in this page, you will see two notification is there. One is notification number 749. This is the similar things is given. In access to the power conferred in subsection 1 of section 29 of the Right to Children Education, Free Education, Compulsory Education Act 2009, the central government hereby authorize the National Council of Education, Research and Training as the academic authority to lay down the curriculums and evaluations of the procedure elementary educations and development and framework and national curriculum under clause 1 of subsection 6 of section 7. And even another notification is given here, SO number 750A. In excess of the power conferred on Section 1 and Section 23 of Right to Children Education, Children Free and Compulsory Education Act 2009, central government hereby authorize the National Council for Teachers Education as an academic authority to lay down the minimum qualification for a persons to eligible for appointment as teacher. So you will see even the qualification if it is given and it is come in 2010, not prior to this. Now you will see here. Subsequently, this notification is there in August 2010, page 34.
Yes.
So you will see here English version of this notification is page 38.
Page 38.
38. So you will see here it is page 30 is given minimum qualification, and let us turn out it page 40.
Yes.
This page 40, paragraph 4, you will see.
Yes.
Teacher appointed before the date of this notification, the following category of teachers appointed for class 1 to class 8 prior to the date of notification need not require any minimum qualification specified in para 1 above. So in this notification also clearly stated, you will see that if the person is appointed prior to date of the notification, then it is not required to have the minimum qualification.
Notification of these days is 23rd August 2010.
Yes. Regarding this matters, you will see here. I just looked at.
Just a minute. So there was a regulation in existence prior to this.
Yes.
Prior to this NCT notification.
Yeah, 2003.
Laying down qualification.
Yes.
As per subclause A, 4A, a teacher appointed on or after 31st September 2001, that is the date on which NCT determination of minimum qualification for recruitment of teacher schools, regulation 2001.
In 2001, there was rule.
So what was the thing in that regulation?
That regulation was applicable for the NCT norms, and then their qualification is different.
So this will not apply to you.
This is not apply to me. If it is applied, then I am no longer as a qualified person.
So this NCT norms, which was in existence
in 2001,
that will not apply to you.
No.
Why?
Because you will see, even 2003 also some notifications come up.
Okay, 2001. Your school was not bound by the NCT regulation.
No, 2001 I was not in existence even in school.
After a teacher appointed on or after 3rd September.
Yes.
See this language here, 4A.
Here is given the teacher appointed before the date of this notification. This notification means you will see, and
no, so read A. Subclause A.
A teacher appointed on or before.
On or after.
Yeah. This a teacher appointed on or after 3rd September 2001. This date of this notification is determination when a qualifications teacher such and such amend from time to time coming to force in accordance with the regulation. So you will see in 2001, it has started the NCT norms. And subsequently 2003, there were some changes.
Now, NCT regulation was For whom? This regulation,
It was for the central government aided for any institute that went on.
it was not applicable to the school,
No, not states.
not state.
Not states. It was for central government.
Okay.
So you will see subsequently 2003 also there were some changes. And NCT norms has come into force to the state in 2010.
So your submission is that NCT norms applicable in 2001 was
Applicable to the central government.
not to your school.
No. So in support of this, you will see this my submission, I beg to just submit, you will see, though it is not the matters of this school, but it is as regard to the effective date of notification.
That is okay. That is all right.
So,
but then effective regulation, that is all right. But then the laid down norms or the procedure there, which take into consideration about the qualification which was prevailing during the time after the 3rd September 2001. This also will not.
No, it is not.
It means the entire this notification will not applicable to you then.
I am coming here to see why this NCT norms notification coming into force now. How it is come.
Can you see SSS scheme, Mr. This is, because this court is a bit confused. You see, it is getting more confused with this submission made by you.
So you will see just little bit.
Either that has to be a case that you either take a stand that NCT norms will not bind you. You cannot say that it will not bind you partially and will bind you.
I'm coming, Yusuf. In this matter, I'm coming. I think I'll be in a position too. Please. So Yusuf, here why I'm saying, because this notification, National Council for Teacher Education notification, 23rd August 2010 has come into force, and in this notification, when the notification is given, the NCT norm will be applicable on 1st April 2010 onward. Then you will see, prior to this, if I'm having this appointment, then it is not applicable to me. This is my submission, you will see. So in this regard, you will
that is if we remain ourselves confined only to subclause 1.
Yes. So
just or maybe clause 4.
Yes, clause 4.
Yes, but then clause is it clause 4 is independent of clause 4A?
So you will see in this case, if you go for this notification, then clause 4 one of them to be applicable, and all the matters is coming in the same way. So here you see this as regard to the notification. So date of notification is the effective date of notification. So my submission is here you receive.
Just one second. Now it's only basically says need not acquire the minimum qualification which is in the rule.
So may I
now you are exempted from having that qualification which is prescribed
with the NCT
by this notification.
NCT norms. So you will see here, just I came to this notification, was a notification as a whole, the first paragraph you will see. In exercise of power conferred in subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009, 35/2009, and in persons to the notification 750 dated 31st March 2010. Already I referred you will see.
Yes.
Issued by the Department of School Education Literacy Ministry of Human Resource Development, Government of India, the National Council for Teacher Education, NCTE, hereby lay down the following minimum qualification for a person to be eligible for appointment as teacher in class 1 to class 8 in a school referred into the clause N of section 2 of the Right of Children to Free and Compulsory Education 2009 with effect from the date of this notification. So you will see it is specifically saying this notification will come into play on the 23rd August 2010, not prior to this. So the persons when appointed and entering the position, so they will not be coming to this notification subsequently issued an exemption is given by this notification. And in this matter,
Then
Your
what
Lordship,
about then? What about 4A then?
so 4 is saying it's a minimum qualification is given. After that, given this, we are exempted. The teacher appointed
4A.
before the date of notification. So before date of notification means this notification you receive, 23rd.
See, it doesn't. This it is only says the qualification prescribed therein will not apply to you.
Yes, sir.
But then at the same time, it says the qualification which was in existence, the prescribed qualification which was in existence after the 3rd September 2001, that will be applicable. Now, which way you escape from that 4A? That is what the main thing.
So this is the notification issues as per my understanding. You receive when this notification is coming into force and applicable to the states. The
So you have nothing to say about 4A.
4 elusive 4 this given the teacher appointed owner after 2001 the date of his NCT determination minimum qualification. So elusive in this when this it is given, first of all it will be the following category teacher appointed such and such need not be required minimum qualification specified. So elusive here in 3rd September 2001 this NCT
Just kindly come back to that the notification of the state government which you referred to earlier at page 20 at page
25.
No, that notification of the state
Notification in 30 elusive this.
page 30.
Yes. Page 30 elusive.
Yes. Prior to that, what qualification was applicable to the appointment of the teacher in your school? Your school was an aided school.
Yes, it is. It is.
Right from the beginning.
In 2003 onward.
The time when you were appointed, it was a private school.
This was private, totally private.
Total private school.
We were the founder teacher of the
And after that, the school was brought under
government.
grantee aid system. And that grantee aid sanctioned some number of posts.
Yes, it is. 4.
4 posts.
At that time it was 4.
So it became a deficit school.
It is still deficit.
Be sure, you see, the court is already confused. Do not make the court more confused.
This is the page 28 elusive. Page 28 elusive. This we received the grant.
Page 20.
28.
(2004).
It was issued in 2004. 17/2004. And 27 is the sanction.
Just a minute. No, this speaks about SSA, isn't it? This page 27.
This was prior to come onto the SSA. Prior to that.
SSA is a scheme, isn't it?
The scheme. But under that
So
government.
your school was not a deficit school or a granting aid school under the state education department.
You will see here, if I go to page 27.
Yes.
Page 27. This you will see subject, let us see, you will see. Block-wise release of fund to 10 numbers of upgrade primary schools under the Sarva Shiksha Vision.
Yes.
This means
So that means that is about Sarva Shiksha Vision.
Yes.
Now, this is in 2004.
In
After your appointment, isn't it?
Yes, it is.
Now, the question which this court is putting to you is that before this notification, your school was in existence, and if you were appointed prior to it. Now, at that position, at that time, what was the position of the school?
So that point of time, it was as a private aided by the government. It was private, but aided by the government.
It was private, but aided by the government. What do you mean by this? There are many system of aids. What kind of aids you were receiving?
So the aids given
see,
only the salary.
This basically the query of the court is directed to find out whether you were appointed in a sanction post. If you say it was under the state aid, now if it is under deficit system, there must be sanction post.
So, Your Lordship, here in this
If it
case,
is grant in aid, there may be lump sum grant in aid.
so Your Lordship, here, as per this notification, Your Lordship, we have prepared the school, Your Lordship.
My senior may slightly stand corrected, my lord. My lord, this school was a private school. Subsequently, by this order, it was upgraded, my lord, to an SSS school under the SSS.
So it means the state never had funded it.
My lord. Only the
So
SSS.
it was never an aided institute under the.
Yes.
Now, then the question comes: what this court would like to know is that after the school was brought under the SSS scheme, was there any change required to be affected insofar as the appointment of teachers were concerned?
Prior to this 2010, there was no change. When these notifications come up, then school is bound by the norm prepared by the government.
So from 2004 till 2010, no appointment was made under the SSS scheme.
No appointment was made.
Not only particularly in your school. What about the?
Regarding others, I don't know, but
Things are not very clear, Mr. Devnath. Whether the scheme makes any provision for appointment.
That point specifically, I
It definitely sanctions certain posts, isn't it?
My lord, four
Literature, science, something, isn't it?
Yes, my lord.
3 or 4 posts are sanctioned.
Four number of posts.
Now, whether the scheme prescribes minimum qualification for those teachers.
My lord, if I'm allowed to my affidavit, my lord, there we have stated. My lord, initially from 2000, whenever prior to 2010, my lord, there were 4 posts in existence. My lord, after 2010, that 4 number of posts is no longer in existence. It has been reduced to 3 number of posts.
So you
Under the scheme.
Under the scheme. So priorly four number of posts were there. Only lump sum grant was given.
And what is this qualification prescribed for those?
Qualification, of course, here we have not stated, my lord.
You will see another.
I'll have to seek instructions.
You will see.
Only with regard to qualification.
You will see some
Because in our
extent.
affidavit, my lord, we have stated that, my lord, if I'm allowed to take my lord to page 2 of my affidavit, my lord, latest affidavit.
Affidavit in opposition by respondent number?
No, my lord. The current affidavit that I have filed before the Honorable Court. That is affidavit dated 17/10/24.
Paragraph?
My lord, there are 3. Page 2, my lord, I'll take my lord to the last paragraph, the implementing agency.
Yes.
The implementing agency of SSS scheme in the state of Meghalaya is State Education Mission Authority of Meghalaya. When a particular school is brought, this is a current situation, my lord.
Yes.
When a particular school is brought under SSA with the approval of the Project Approval Board of the Government of India, this Government of India sanction will have to be there, my lord. And as per norms of the RTE, that is Right of Children to Free and Compulsory Education Act 2009, 3 sanctioned teachers post in each SSA school is allowed, supported by SSA scheme for providing the financial assistance. So this is the current scenario, my lord. 3 teachers as per RTE and central government norms are 1 teacher for science and mathematics, 1 teacher for social studies, 1 teacher for language.
Yes.
But earlier, my lord, as per state norms, 4 teachers were initially allowed to be appointed under the SSA upper primary school. So number 1 was 1 teacher for science and mathematics, 1 teacher for social studies, 1 teacher for languages, 1 teacher for general subjects, known as the 4th teacher. So here also we have stated, my lord, but this modification of appointment of 4th teacher has been discontinued, done away with effect from the year 2010 by the state government.
Yes, but then what about the qualification? And
See-
what about the teachers, those who were already in the service?
Your Lordship,
Now, as far as
in this respective matter, Your Lordship,
Just a
may I-
minute, just a minute, just one of you, just.
Lord,
Yes.
as far as respondent number 7 is concerned, my lord, subsequently he obtained a qualification also.
But that is all right. But then what is the qualification?
My lord, a science teacher, that exactly.
No, just where is that is shown? Some, you see,
Yes, I understand what has fallen from your.
kindly show us where it is prescribed that qualification.
Your Lordship, page number 46 is my compilation. If you kindly go through, Your Lordship.
My lord, we have also stated in.
Yes.
This is the Ministry of Home Affairs, Ministry of Home Resource Development.
Ministry of Human Resource Development, yes.
This notification dated is 18 June 2012. Your Lordship.
Yes.
So in this notification, Your Lordship, it is given the state government is not having the sufficient qualified person and relaxation was sought and government of India has permitted.
What is that? Where is that part?
So, Your Lordship, here, may I read, Your Lordship? Page number 36, Your Lordship.
36. You said 46.
47. This, very good. This 48 ka 14 like that. So 47. Whereas the state government of Meghalaya, by its letter dated 21st February 2012, submitted a proposal to the central government for relaxation of the requirement of the minimum qualification for the appointment of teachers laid down by the council under sections 1 of section 23 of the SED Act.
Yes.
And then thereafter in this notification is given, central government has considered. Central government has considered if there is an even.
Where is that? Where is that part?
Para to relaxations granted under section under this notification shall be laid before for the period up to 31st March 2014.
Where is that?
So this is
You are reading from?
page 47, elusive.
Yes, which part you are reading?
Paragraph 2, elusive.
Paragraph?
Paragraph 2. The relaxation granted under this notification shall be valid for the period up to 31st March 2014, subject to the following conditions, namely. So hereby, Your
Just a
Lordship.
minute, just a minute. Let us finish it. Let us read it only in part. So this qualification would not apply to you. It was relaxed.
Yes. Even the state government is relaxed. And in this notification,
Just a second. So it was supposed to be valid till 2014, isn't it?
2014.
So that is all right. That covers you. But then it says the subject to the fulfillment of following conditions. Now, what are the conditions? Now, see, Mr. Demnath,
yes.
This probably would concern fresh recruiting. Okay. Now, so far as you are concerned, is there anything specifically for the existing teachers.
So here, Elusive, as per my knowledge goes, for the existing teacher, the state government has not notified other than this.
It's okay, but then so far as this notification is concerned, doesn't say, it is silent.
So here,
And
Elusive,
there is nothing, no direction that the persons, those who were recruited earlier, should be ousted from service.
yes, there is
Nothing,
not.
nothing is.
Okay. Elusive, here in this, in page 48, it is given in the state newspaper subparagraph Roman 4, page 48, Elusive.
Page
48.
48. Subparagraph 4, Roman 4.
Roman 4.
Yes.
Advertisement for the appointment of the teachers shall be given wide publicity, including outside the state.
Yes.
So, if any advertisement to be given and then appointment wide publicity, it is come after 2010, not prior to this.
That is all right. You see, you have said it so many times. Only thing is that, see, you have taken your stand so far as it appears from reading of these things, that the qualification which basically was prescribed could not have been applied in your case because the state government sought for an exemption and that exemption was granted till 3rd March 2014. So that way you are protected because your appointment was much earlier. That is what appears to be your argument.
And another aspect is, in my case, advertisement.
Then you could have, instead of taking us to so many notification, you could have taken us to this at the very first instance. And you could have said that this, whatever qualification is prescribed, is not applied to you because your recruitment was prior to 31st March 2014.
You Lordship, I came later on in this part. Because of it, the notification when it is happened, and then from the since 2002, how it has come up to just to satisfy to the court. Why I am coming? If I come jump here, you Lordship, then it is make some complications. So that's why I went there.
Yes.
So, Your Lordship, subsequently, Government of Meghalaya has given the options if anybody interested to have the additional qualification, and they can take out of this notification.
What is the purpose of going into all those things? If you are saying that you are exempted from those prescribed qualification, that is good enough.
No, Your Lordship, I'm in my affidavit I have taken. That's in my qualification. I have obtained this subsequently qualification for science. And
Where is that?
And this one is Lordship in 49, page 49. Government allowed me to obtain the additional qualification.
No, and then how? Page 49.
Yes, Your Lordship.
Yes.
So this was the no objection, and after the no objection, Your Lordship, I have gone for the.
But then it seems that some parts are not filled up in this.
Some, but this is the thing given, and after this, I have obtained my qualification.
Higher studies. And then where is your qualification? Then you obtained. What is your qualification you obtained?
This one, page 50.
This was granted in your no objection is granted. What is the date? Month? 18/3/2014.
18/3/2014.
Page 50.
Yes, sir.
Yes. This is your
certificate.
For
this, I have qualified for science.
now what is this qualification? Degree?
It is not degree, it is PWC. Senior secondary.
Senior secondary certificate. But even then, you see, like if you say that the qualification norm was not applicable to you, so these also basically.
No, Your Lordship, because I have given my affidavit, so it is brought to the notice of the court.
Yes.
So this is my case, Your Lordship.
Okay.
And is regard to this date of notification, which I have given in my compilation, this 1998, volume 8 SCC, 282 page, Your Lordship, 51.
This is a page 51.
51 in my compilation.
Yes.
So, Your Lordship, in this, though it is not the allegation matter, but it is logic behind it regarding the notification. Paragraph 3 and 4.
This is concerning what?
This is concerning Your Lordship, the effective date of notification.
It is not in dispute. What is the thing? There is no dispute to the fact that you were appointed for way back in 2002.
No, Your Lordship, my learned friend has raised this one. That's in after this constitution amendment, and it is given in 2001 on NCT norms will be applicable, and after 2000.
See, once that subsequent thing at page 49 or page 46 and 47, once you show that this qualification prescribed was exempted for the state of Meghalaya, that is good enough. Why should you go into? You say like get entangled with those things.
I just thought of it this also that effective date notification I put to the notice of the court. So another citation I wants to rely Your Lordship, this court.
On what point?
This one, Your Lordship, 2011 volume 3.
What on what
SCC
point?
436. In this judgment, it is given this there is a settled provision of law. No one to be appointed without following the due process of law. Without advertisement.
And when is the appointment of the petitioner made?
Petitioner made, they're shown in 2014, and he came with the appointment letter in 2016 in the court.
His appointment was made in
2014, and then he came in the school in the 2016. After that,
2014, he was in some other school.
No, he is having the possession of this appointment letter issued by the president, and after this in 2016, he was in a position to procure the one letter from the DC that he was getting the salary. That time he came to the school.
Okay, so his appointment basically was regularized in 2016. That is what his case is.
His case. And when he came, and then after that, the objection is raised by the member of the managing committee. That's they don't know anything. How is it?
His initial appointment in the school was in what capacity? His first appointment in 2014.
He is seeing as a.
Where is that appointment of 2014? Petitioner's appointment.
This is here in the compilation.
This will be in that compilation which Mr. Samesh has. Yes.
Just 1 minute. This is, I think, it's page 56 in my compilation. You will see. Appointment letter.
That is there in his compilation of Mr. Shangrisha.
2nd May 2014. It is issued by the President.
Yes. So that is after the expiry of that exempted period, isn't it?
Yes, yes.
Because exemption was till 31st March 2014. Yes. Okay.
Sir.
We'll conclude.
My lord, shall I give a short reply? The reply, my lord. Now, Lordship, you kindly see the paragraph 3 of the affidavit filed by the respondent managing committee school. They say that the NCT qualification is applicable to him.
That's all right. But then once law is supreme, isn't it? The mayor saying will not.
I'll come to that.
Now, what do you have to say about those notifications which Mr. Devnath has made?
Now he has cited. Now when we come to page number 38. 38. The same compilation he has written. His own compilation.
Mr. Devnath's compilation.
Yes, compilation.
Yes, page 38.
Yes. And then he has quoted that page number 40. Teachers appointed before the date of this notification. Well,
page 44.
Paragraph 4. Yes. Paragraph 4 of that notification.
Yes.
The following categories of teachers appointed by for class 1 to 8 prior to date of this notification need not acquire the minimum qualifications specified in paragraph 1 above. Now, what are the categories of the teachers? A teacher appointed on or after 3rd September 2001. That is the date on which the NCT determination sunset regulation as amended from the time came into force in accordance with that regulation. Provided further that a teacher of class 1 sunset, well, this is not relevant now. Now, a person who is appointed under that 2001, who are appointed under 2001, is not required to fulfill this NCT norms of 2010. Because and now certain norms is available, page number 41. In exercise of the powers conferred the clause
page 40,
41,
yes, 41.
41. The I of the subsection 2 of section 32, read with the National Council for Teachers Education. The council hereby makes the following regulation to amend the census 2001. Now, when we come to the next page, page 42.
Yes.
Well, there are two categories: elementary, primary, and upper primary. Lordship, in the table.
This is 2003, isn't it?
2003.
After the appointment of the respondent number 7.
Yes. In 2001 also, he did not annex. Madam. He did not annex. But it is a repetition. Now, upper primary, Lordship got in the table. Elementary, number 3, elementary, A and P. A concerned with primary. P, we are concerned with upper primary. Lordship got it. Now, senior secondary school certificate or intermediate or its equivalent and diploma or certificate in elementary teachers training of duration of not less than 2 years or such or graduate. Now, those who are appointed under this, they do not need to fulfill the NCT norms of 2010. Now, we would examine whether petitioner was appointed.
Now, the norms of NCT, this was not applicable before the RT Act came into existence. Only after RT Act came into existence.
Well, I have seen, also at point of time, my esteemed colleague was advancing argument that NCT norms is not applicable to the state. It's absolutely incorrect. So can you see?
No.
NCT norm, the Act. These NCT norms of 2020 are then, in 2001, were laid down by this authority. National Council for Teacher Education Act 1993.
Yes.
And Lordship, can you come to page, the section 1, the next page. Extend.
Yes.
It extends the whole of India. So where is the question of exclusion of state?
No, whole of India to which institution?
My lord,
Saying
that
whole
I'll
of
come.
India,
I'll come to that point. Now, it shall come into force on such central government by notification is appoint, save as otherwise provided by this Act. The provision of this Act shall apply to institution, students and such, schools imparting primary, upper primary, secondary education, and colleges providing senior secondary or intermediate education, irrespective of the fact, by whatever names they may be called. Teachers for schools and colleges referred to in clause, and such. Now may I come to the next one, subsection, definition of recognized school is also there. Now the school, subclause KA. School means any recognized school imparting primary, upper primary, secondary or senior secondary education, or college imparting senior secondary education, and includes a school. Now, Roman II, a school receiving aid or grants to meet all or part of its expenses from the central government, state government, or local authority. A school not receiving any aid or grant to meet all or part of the expenses from the school, central government, state government, or local authority. Now, this Lordship, kindly come to section 12. Function of the council, section 12.
Yes.
Now, it shall be the duty of the council to take all such steps as may be think fit for ensuring plan and coordinate development of teacher education and for determination and maintenance of the standards for teacher education and for the purpose of performing its function under this Act. Now, D, Lordship is clause D, lay down guidelines in respect of minimum qualification for a person to be employed as a teacher. Now, my lord, we come to section 32.
Teachers in recognized institutions.
Yes.
Now, what is recognized institutions?
That definition, my lord, recognized institution. Recognized institution means an institution recognized by the council under section 14.
Yes.
Now, Lordship, section 14. It is there. Every institution offering or intending to offer a course or training in teacher education on or after the appointed day may, for grant of recognition under this Act, make an application to the regional committee concerned in such form and in such manner as may be determined by the regulation.
So how we will know that institution was recognized?
Therefore, now these norms was, my lord, framed under this Act. And now, Lordship, is in section 32. The notification, including the compilation, is framed under
Now,
this section 32.
if this Act is to be taken as an Act regulating the education in the school and the offence,
yes,
then what happens to that School Education Act of 1981? Meghalaya School Education Act of 1980.
Therefore, my lord, education is in the concurrent list under 42nd Amendment of the Constitution of 1976. Now, once, my lord, the state has independent to bring their own education regulation. But the moment, my lord, the central government brought in, the law is very clear, it is the central government that prevails.
Even this institution of the state.
Oh, it's a concurrent list, my lord.
Can
It is
be
in the
concurrent
it is in the concurrent list. Lordship, kindly see the Constitution also. Education is a concurrent list.
That is okay. There is no dispute.
That is undisputed one.
Apologies, my lord.
Undisputed one.
Whether the petitioner has the locus to challenge all this, my lord.
No, there is no question of challenging.
The state
There are
cannot
no
decide my
challenges coming
territory.
here. Now, even if we assume your submission is correct, where is the evidence? The school was basically recognized under Section 14.
But therefore, now if it is not recognized, the school is not recognized, my lord. Then the school was brought under the SSA from 2004. Now SSA is under the control of the NCT. The qualifications, the norms of appointment of teachers, qualification is controlled by the NCT.
You show us all those norms.
Lordship, therefore, Lordship is Section 32 of the very Act we are referring to. Section 32 of the Act.
These are. We are not coming to any conclusion. Things are getting more complicated. You see,
we will try
are
to
coming into
concretize.
conclusion.
We will concretize in, my lord.
With respect
We'll
to
concretize.
submission,
It
the
was-
petitioner
he's
is
the-
misleading
he's-
this honorable court. He should stick to his case, my lord.
No, it is
He's
uncalled
venturing
for.
beyond
man.
his pleadings, my
It's
lord.
uncalled for on the part of the
But
government.
even
council.
what happens to that exemption? Just tell us.
I'll come to that
how
point.
do you deal with that?
I'll
exemption?
come to
Your
that.
Lordship, before going to
I'll
this
come to that point.
exemption,
Because
Your
in there,
Lordship,
You just deal with that point. There is no use of going here there.
so Your Lordship, just
but
I
therefore-
can just refer one
Just
simple
hold
clarification.
on.
it is, my lord, with great respect, difficult to handle a case with this nature.
He's going beyond his case, my
No, no, no.
Sit down, please.
It is. I never interfere when my learned friend argue. It's a very bad practice, my lord. We never inherited from any city.
Yes, please carry on. Carry on.
Very,
yes.
very unfortunate. Unfortunate. Now, my humble submission is that 2010 norms given certain relaxation to teachers already appointed under norms of 2001. Now we have to see, my lord, if he has appointed under 2001, relaxation, my lord, that will come, page number, my lord, page 38, the same compilation.
Yes.
Here has the relaxation has been given, but the norms has been given 2 years diploma, elementary or B.Ed. Those qualifications are there. And teachers eligibility test. Page number 39, Lordship has seen. Page 39 of the compilation of my colleague.
It lays down this essential qualification.
Essential qualification.
Yes.
Now, 2 qualifications are provided, either 2 years diploma, B.Ed, or special education, and teachers eligibility.
Yes.
Now we will come to the relaxation. Page number 40, the certain relaxation is that those who are appointed under 2001, they don't need to fulfill this 2 essential norms. That is the meaning of para 4. Without para 4, all candidate has to fulfill these 2 norms. But para 4 has given a saving clause to those teachers who are already appointed.
Now, what is the meaning of this notification of Human Rights Commission? Page 47.
47. Page 46 and 47, right?
Yes.
Right.
Come to page 47.
Right.
Subpara 3. Now they are
Para 3, yes. Now, therefore, it says, in exercise of powers conferred by subsection 2 of section 23 of the RTE, the central government hereby relax in respect of the state of Meghalaya the minimum qualification notified by the NCTE 23rd August 2010, amended 2011, insofar as they relate to classes 1 to 8. Now, what relaxation, my lord? What relaxation is given is that 2-year diploma in elementary education. So the condition number 1 of 2010 was relaxed. 1-year bachelor degree in education. Now, Lordship may keep in mind, teachers' eligibility test is not relaxation. It's not a relaxation. Now, my lord, we continue, and this relaxation is up to March.
Yes,
31st March. Now, that relaxation will effect from what? Relaxation effect from 23rd August 2010.
Yes.
Now, this Lordship, can you see?
Relaxation occurred from 23rd 2010. Okay, anyway, it can be.
It may be behind.
Yes.
Still, my lord, if he was appointed as per the 2001, then he's secure. But if he was appointed,
What is the norms prescribed in 2001?
2001 is, my lord, therefore, where the page number, Lordship, can you see? Page number 42.
Now,
GSNX, page 42, 41 and 42. His own compilation of my friend.
This is amendment regulation of 2003.
Yes. According to me, this is the same of 2020, 2002, 2001.
This is 2003.
2003.
Yeah. Yes.
But
then how do you say it is same 2001?
My lord, according my lord, it is the same no criteria. It is the same criteria. A lordship diploma or certificate in elementary education teachers training of duration of not less than 2 years. So at that point of time, 2002, if he has diploma or certificate in elementary education or B.Ed, then the relaxation received by the state government is in his favor.
Just a minute. One second.
Right.
Now, this is what is National Council for Teacher Education? It concerns teacher education, isn't it?
Teachers will be for appointment as a teachers.
No. It's National Council for Teacher Education.
Yes. They have provided, they have provided
what it is formed with what these things? See, this deals with teachers' education, isn't it?
Recruitment of teachers, madam. Lordship may start from page number 41.
See clause E.
Yes.
Definition E. Definition 2, clause E.
Lordship is referring to that 1973 Act.
1993 Act, the National Council for Teachers Education, which you were referring just now. Come to 2E.
Well, 2E, institution.
Yes.
Means an institution which offer courses or training in teachers' education.
Yes. Right. So, which way this applies here?
Now, therefore, my lord, Lordship kindly see the rule, the section 32.
It is not at all applicable here in this case.
No, Lordship. Otherwise, the notification of 2013 and 3 annexed in the compilation of Mr. Nath, my friend, was issued in the same act.
See, it lays down qualification only for the purpose of teachers of those recognized institutions. So, institution means a teacher's institution, a teacher's training institution. So, this act doesn't come here, doesn't apply.
Lordship kindly see page number 41 of the compilation. 41 of the compilation. 41.
Yes.
Lordship, in exercise of power confer under clause EI of subsection 2 of the section 32 read with section 12T of the National Council for Teacher Education 1993.
Yes.
Therefore, this authority has.
See, these are for the meant for the institutions where teachers are trained.
Lordship, can you see?
These qualifications are not for appointment in schools.
Lordship, can you see section 2 in the middle, extent of amendment. The provision of section 2, applicability in city determination of census 2001 shall be substituted by the following. This regulation shall be applicable for recruitment of teachers in all formal school established, run or aided or recognized by central or state government. Other institute authorities for imparting education at preschool, nursery, followed by first 2 years in formal, elementary, primary, upper primary. So it is purely for the appointment of teachers in all those schools, not only for those B.Ed schools, B.Ed education colleges.
Not very convincing, Mr.
Well, it is very functionality. In the first schedule, other than the notes and density determination, 1001 shall be substituted by the following schedule annexed to this regulation. In the schedule, we have read out, my lord, page number 42. In the qualification, they have mentioned. So if number 7 was appointed in fulfilling this, then the relaxation received by the state government in 2012 till 31st March 2014 is applicable to him. But if he was appointed without fulfilling this, he cannot take shelter. And in the last occasion, he argued that yes, this notification 2003 has saved him, saved his service.
Kindly come to section 12 of that 1993 Act.
Section 12 of that. Yes, ma'am.
Functions of the councils.
Yes.
Come to clause D.
D.
D, lay down the guidelines.
Yes. Lay down guidelines in respect of minimum qualifications for a person to be employed as a teacher in recognized institutions.
There are 3 dots. There are amendment.
Yes.
Please come below. Just see which word has been omitted.
The words insofar as Lordship is referring to.
Yes.
The words in school or omitted by
So the school has been omitted.
Article.
The school has been omitted.
Well,
the one school has been omitted means this minimum qualification is not taken for schools. Not to be taken for schools.
2011, my lord, amendment. At the bottom, Lordship is referring to.
Definitely. See,
2011 Lordship kindly see. It was removed. in
See,
2011.
we are that national.
Yes, 2011 man. The words in school or omitted by
Act of 2011,
2011.
Section 5 with effect on 1/6/2012.
2002.
Yeah.
Now his appointment, my lord. His appointment is in 2002. So when he was appointed, the act was very much in existence. Enforceable.
There remains confusion, not very clear. I don't think the learned councils also have any clear conception about that.
And it is not the case of state government that this relaxation is applicable to him. They just simply say adjustment. Being a founding teacher, his service was adjusted. That is the case of the state government. And as a last point, if Lordship allow me to come to that relaxation, relied by my friend, page number 47. When we read this relaxation together, my lord, teachers' eligibility test is not relaxed.
In your written notes, you have raised all those things.
My lord, it's the first time he is raising. Using affidavit, he said
No,
that
because these low points, this court will have to record it minutely.
But we can just concretize it in a brief note we can supply. The substance of our
Because it will be difficult. Because now each and every minute points are coming up. Page 47.
47.
Yes.
So 47 admittedly teachers relaxation education test is not relaxed. What was relaxed is 2 years diploma with regard to the instant case.
1 year bachelor's in
Yes,
education. and
that is there. But regard to teachers eligibility test is not relaxed.
When this teacher eligibility test was introduced?
My lord, that is also from 2010. 2010.
2010.
Yes.
I think he was improvement was much before that.
That is why it was much prior to that one. And Lordship kindly see page number 84, 448, Roman 6.
Page 84.
Sorry, 48. Page 48.
Yes.
Roman 4.4.
Yes.
Point 6. The state government and other school management shall ensure that teachers who are appointed under the relaxed qualification norms acquire the minimum qualification specified in the state notification. State notification 2000.
Anyway, this is for the state to see. I don't think you have a right to see all those things. It is for the state to ensure. See.
Therefore, my lord, his appointment was
whether he acquires it or not. That state will ensure. You have no role there.
Therefore, if he was qualified, properly appointed, and my appointment is wrong, I have no case. But
Your
here is a
appointment
person.
wrong. You see, your whatever the thing, whatever his fate is, your appointment is clear, and then you admit it. But there was no advertisement, nothing.
Yes. So his.
So only thing is that whether the application of norms, as it is in your case, whether it was same for him or not, that is what is to be said.
But, so if his appointment is right, I have no case. But my appointment is wrong and his appointment is also wrong, then ultimately Lordship can quash both the appointments.
That is what is to be seen.
Yes, that is my pride.
That is what remains to be matter of controversy.
Otherwise, Lordship cannot allow the other wrong party to survive and another party to wipe out. The law is a single and one only.
Lord will kindly appreciate. He is supposed appointment of 2014. My Lord will kindly look at the conduct of the petitioner. His appointment is thoroughly not known to anyone. Then he files
that I have a strong objection. They cannot say that.
No, it is a part of record, my Lord. Then he files a complaint letter saying his salary is not being disbursed. There is no such approval on record.
See, Mr. Bhattacharjee, you are still basically confining yourself with the factual aspect.
Yes.
Try to help the court and so far as the law points are concerned. You say, what should be the set of qualification?
My Lord, that
you just clarify us how much it will bind the state,
my Lord,
and to what extent it will not bind the state. You better, I think, address the court on those instead of going to those. You have taken note of all those aspects.
Your Lordship, may I just clarify this matters, not for big argument. This here my learned friend has argued this matters, and so many matters has come up now. So, Your Lordship, I was just confining the similar matters, and then after this, I just shortcut. So whatsoever this petitioner is saying at the moment, so many aspects has come out. So you will see if I come up here just for clarification, not for argument, page number 40 of my compilation.
Page number 40, 40.
40. Then position will be clear, Your Lordship.
Yes.
This I have just referred earlier only paragraph 4 because only for the confining this my qualification. So Your Lordship, if I come this paragraph 5,
Yes.
it will be clear, Your Lordship.
Yes.
How it is come up. Paragraph 5. Teacher appointed after the date of this notification in certain cases.
Yes.
So it is most important, Your Lordship, here.
Yes.
When a private government or local authority or a school has issued an advertisement to initiate the process of appointment to teacher prior to the date of this notification. So if I come to here, Your Lordship, it may happen that notifications come into force, but earlier advertisement was there. Then such appointment may be made in accordance with the NCT determination minimum qualifications for deployment teacher in school regulation 2000 as amended from time to time. So it is clearly specified in this when relaxation is given that if any advertisement already set and then going to be appointed, then in such situation NCT norms to be followed. So it specified that central government whatsoever given and state government having separate set of rule. So in such situation it is given central government norms to be NCT norms to be followed. So here in my case, already I am not having concern about it. That's why I didn't mention earlier. So here in this case, petitioner say there's no, this norms should be NCT norms to be followed even to in my case. It is totally misleading. If you go in this paragraph, it is clearly stated it is a notification.
No, it says that it should be made accordance with
Yes.
NCT.
So if advertisement set forth, suppose today advertisement.
No. You see, I do not know, Mr. Devnath, what you are arguing. The courts, clause 5 says that if any appointment is initiated prior to the issuance of this notification, then in such a case, the norms laid down in the regulation of 2001 that should be followed.
Yes, Your Lordship. Correct.
So regulation 1 is of this thing. It's the norms of NCT, not a state government.
No.
Then?
So then it is coming up this when this notification given under the RTA 2009 and 2010 SS come into force. That point of time, if any appointment going to be made, and earlier notifications given for the appointment, advertisement any, then it will be follow the NCT norms. So whenever my appointment prior to this, there is no questions of this.
Prior to this means?
Prior to this notifications. Prior to this notification, I got appointed.
I do not know. So clause 5 does. You do not know what you are trying to mean. How, which way it helps you, you have not understood.
No, see here, my learned friend is saying that the norms of NCT is applicable to me. So I am saying that this is the
norms of applicability NCT as it was prevalent in 2001. That is what is applicable. It did not say that 2023 is applicable.
So here another this would say if I go this. So you will see here this another aspect is there here. You see, my learned friend is referring this act about it. But what the government of Meghalaya rule? He didn't say. May I give this one copy? I just downloaded this copy. The rule of this government of Meghalaya as regard to this.
I think
this
Mr. Devnath, you reduce your submission.
No, just I'm
make
giving.
A gist of that.
No, just I'm stopping this only this rule I can give you.
No.
This copy of the
you just make this thing. You can give it to us. We'll see it now. But then I think you give a written note of your appointment. Mr. Sanglesha will do that.
Rule 7.
This 2011 notification, yes. What does it say?
So you will see even in this respect to this notification regarding this paragraph 5 of this page 40, it is saying that such appointment may be made.
You are reading what section?
So this rule 17, you will see, rule 17 is given the clear about it. what are the conditions will be there if the appointment made even after the notification come into force. What is the relaxation or other given? This is the state government notification. And section 23/2 also is referred, and this is the matters.
What does it say?
So acquiring the minimum qualification under the provision of the section 23/2. So what's the government of Meghalaya has prepared the rule. So he's
You
not
read
having,
it, then why you are reading only headline and then
so state government shall provide adequate teacher education facility to ensure all the teacher in the school referred in subsection subclause 1 and 3 and clause N of section 2 who do not possess the minimum qualification laid down under subsection such and such rule 15 at the time of commencement of this act and acquire such minimum qualification within the period of 5 years from the commencement of this act. So you will see here in this even government of Meghalaya, he's found that some teachers, even they are not having the qualifications at the time when this government is notified. So in such a government has issued the notification 2011 and subsequently in the
then
rule,
same for benefit to go to him also.
he is not appointed.
He was appointed.
Prior to this notification coming to force, he was not appointed. He cannot ask even this relaxation.
No. You see, if you say it applies to you, then it will apply to him also.
No, I am saying, see, in general, you see what the government of Meghalaya rules and application was there. Earlier, put as some.
I do not know. This provision neither helps you. We do not
No,
know.
you see, just rules, whatsoever rules thereof in the state of Meghalaya after this.
You give it in this thing. So now things are getting totally, you see, like inclusive. You see, like where we are going, you do not.
Even the rule which was referred by my senior, page 40. Here also it says not there is not a direction. It doesn't.
You see, it should come from you basically, State Council. That is your role to clarify what should be the exact norms and all. But then you are silent on all those things.
No.
You just tell us, say at least say with authority that what you are following and what should be followed by the state. Instead of harping on the factual aspects.
I may be allowed to refer to my affidavit only. What are the norms are stated in my lord affidavit page 5, my lord, of the latest affidavit.
Yes.
These are the current norms for graduation. My lord, this will be class 4 to class 8, my lord. This is specified graduation and 2-year diploma in elementary education, or graduation with at least 50% marks.
That is 2011. And before that? As per the site NCT qualification so and so, notification number so and so 2011. Before that?
Yes, before that we have not stated.
So that is what is needed. Our entire argument is made on with that thing. You are referring to something which 2011.
Because, my lord, the petitioner's appointment, which petitioner is, my lord, adjudicating before this honorable court is, my lord.
Does it, whether your affidavit deals with the qualification which was prevailing at the time in the year 2002? Anywhere? Mr. Sangleshu, I think it's better you give it in writing. That's the point.
Yes,
of
yes.
law and
Yes, we'll briefly reproduce our and submit.
Not learned counsel for the parties. That's at the request made, parties are allowed to file. a written note of gist of their argument. By?
Within a week, Lordship permits.
Will it be possible within a week? Within a week?
Well, I'll pray for 2 weeks.
Within 2 weeks. List accordingly. Probably we are venturing into arenas where we are not required. Let us see. And this way things are also becoming
right. If we go by the principle of pleading, it will not be complicated.
See, yes.
Mr. Majumdar,
For dismissal. On the previous occasion also there was no appearance.
In fact, on the last occasion, I placed a decision, my lord, because the petitioner earlier approached Allahabad High Court, my lord. There are certain directions.
On the last occasion, petitioner did not appear. Today also is absent. So we will not decide on merit. We will dismiss it. None appears for the petitioner. Dr. Mujika, DSG is present on behalf of the respondents. On 17/3/2025. Also, there was no appearance on behalf of the petitioner. Stop. It appears that the petitioner has lost interest in pursuing this matter. Accordingly, this writ petition stand dismissed for default. Probably they have realized the outcome, what might be the outcome.
Look, Mr. Majumdar was appearing. I heard his name is recommended now. Mr. Majumdar, Rajesh Majumdar, if
Yes.
yes. recollects.
Achha, from counsel from Guwahati. But then he is normally
He's likely to be elevated. His name is recommended now.
elevated. Yes?
A judge, Guwahati High Court.
In Guwahati High Court. So that is why he is not there.
Maybe one reason. he should be interested. I don't know. That's off the record.
You know everything. Yes.
Item number 20.
Yes.
So we have a limited time, my lord, if Lordship may take up after a
This will
week.
take time. This will be time
It
taking.
will take time.
This is a service matter again.
Service matter. Dismissal from service.
Dismissal from service. CRPF.
CRPF.
And dismissal on what account?
On the ground that there is a misconduct on his part.
Forged documents for his father's traveling and claiming reimbursement.
Forgery of the document at the time of enrollment.
But in the office records, he forged the documents. He had some access to the office records in BSF. He forged the documents there.
There was an inquiry held.
The inquiry held.
And he
took part in the inquiry.
He has given a minor punishment. Appeal was preferred. And appellate authority without jurisdiction has converted into major punishment.
Enhanced. Enhancement.
Enhanced. Yes, that is the issue.
I think there is some law.
Well, we'll settle. We'll try to
Just
place.
see. Is there?
I'll place my support. There are laws both
Joint prayer.
in his favor also, my favor also.
Okay, the request made on behalf of the petitioner. This is met after 2 weeks.
Deeply.
Deeply.
Number 26.
Yes. What is this revision about?
Well, here what happened, my lord, the respondent.
Short matter or long matter?
It's otherwise short matter, not very long matter.
This court will understand.
Very small matter.
Yes.
But of course, there are maybe some minor fault on our side also in pursuing. Here, what happened, my lord, the respondent was, because there are regimental shops in army areas, my lord.
Okay, allotment is what?
Allotment. So they're leased out for 1 year, 2 year for opening grocery shop, mithai shop, sweet shop, some mobile repairing shop, and all those for the purpose of jawans of the unit, my lord. And those are now. Some few years back there was a policy change, my lord. Earlier those were leased out to civilians, my lord. Now a decision has been taken that this will be leased out to ex-servicemen or orphans of ex-servicemen, or something like that. The policy
Friends
change.
of the ex-servicemen.
My lord.
Ex-servicemen or family of the ex-servicemen.
Ex-servicemen maybe, or the family of somebody who are somebody died in
Those
army.
who are connected with the army.
With the army, my lord. Now, my lord, here the respondent was occupying a shop in Umurai cantonment, my lord. And she, instead of vacating even after completion of the lease period, she went and filed a civil suit, my lord, in the trial court. Some interim order was passed. At some point of time, because of their non-prosecution, the suit was dismissed. Interim order was vacated, my lord. Only interim order was vacated.
No.
Yeah. Then they went and filed an application. But before they filed an application or subsequent order was passed, they were removed by the army from the SOAP. The respondent was removed. Then they filed an application, and the learned trial court has granted prospective
restoration of status quo ante.
Ante, my lord. And what happened, my lord, in regard, because the same respondent was occupying many shops in those, I think 4 or 5 shops, she and her family. In one of the matters, they came before this honorable court, my lord. But I'll just draw your lordship's attention to page 127. This is order passed by a division bench of this honorable court, my lord. Same petition, same person.
Yes.
This is page 127. This is
yes.
We filed an appeal. We filed an appeal against the order of the learned single judgment.
127. Yes.
They filed an appeal, my lord.
Yes.
Now the appellate order is the grievance of the writ petitioner is to the high-handed manner in which the respondent authorities evicted the writ petitioner from one or more shop rooms where she had been inducted for a limited duration. By way of justification, the respondent authorities say that the writ petitioner appellant overstayed her welcome and was liable to vacate the premises. Though there may be no equity in favor of the appellants in this case, in the system followed in this country governed by the rule of law, no person or the high or mighty can take the law into its own hands and evict a person, even a ranked trespasser, without resorting to the procedure established by law. The appellant's articles were said to have been inventorized and kept aside, and the respondent claimed that the appellant refused to receive the articles even when offered. Pursuant to an observation by this court last week, the articles have been handed over to the appellant, though the appellant claims that several of the articles in the premises have gone missing. As to the missing articles, if any, it will be open to the appellant to take appropriate steps in accordance with law for the possible recovery thereof. As far as the respondent authorities are concerned, since the act is done and there is no equity in favor of the appellant cannot be put back into possession. However, the respondents will pay a token cost assessed at Rs 10,000 to the appellant. The respondents are reminded that whatever may be their might, they must act strictly in accordance with the law and not resort to summary eviction without following the due legal procedure. Therefore,
that is for future. It's an advice for the future.
My lord.
Yes.
So, my lord, this order was passed on 26/7/22. Same premises, my lord. Same Umurai cantonment. Neighboring shops, my lord. One shop. Now,
if it is the same shop,
no, my lord.
Not same shop.
Not the same shop.
She was occupying three shops or 4 shops.
2 shops.
This is not in respect of the shop.
Not the same shop, but a similar shop, my lord.
Similar shop.
In one she was selling chicken, my lord. In one she was selling some mobile repairing shop.
Okay, so why it is revision? Why it has come by
We have come on revision against the order of restoration of status quo, my lord. But I'll take your lordship to the impugned order, my lord. Page 100.
There is a civil suit pending.
Civil suit, my lord.
Basically, my lord, they have challenged the order passed under 39(2)(a). Under order 39(2)(a), which is an appealable order under 43. Order 43, my lord. It's an appealable order. Not even that, my lord. The order which is assailed before this honorable court is dated 2023, my lord. And your lordship is aware that as per Article 116, the upper limit is 90 days. There is no explanation whatsoever in the
For filing
application.
revision.
Yes. Even the delay has not been explained.
No, if there is a right to appeal is available,
Yes,
then why the revision be filed?
absolutely. It's basically, my lord, maybe to surpass the delay. My lord.
Yes, Dr. Mojika, how do you overcome that part?
But that is true, my lord. But our only case is, my lord, why we invoked 227, my lord. In respect of 5 shops, I believe, my lord. And all shops are same right, title, interest, my lord. For some matters, they're coming to High Court, my lord, invoking writ jurisdiction. For some shops, they're filing a civil suit, my lord.
But then for all other, they have separate cause of action. Well, everything will not come under one umbrella. Now, 227, as you know, the power of superintendents aimed at, you see, like keeping this
Court within their bounds.
Court within the bounds, yes.
That is what. Now, until and unless there is something by which you can project, there is gross abuse of process of law or gross error of law, or the trial court has done something which shakes the conscience. 227 normally in regulation suit will not be.
That's true.
Except probably in arbitration matter, things may be a bit different, where revision is barred, or there is no, you see, like provision to challenge that. But then for you, it is not that. And law is very much clear. If appeal lies, revision will not lie.
Well, why we filed? Well, the mainly reason being that once the part has been it has been carried out, my lord, and then without verifying that part and restoring the status quo.
Where is the jurisdictional aspect involved here?
For jurisdictional aspect, only to that extent, my lord, that court, while passing or restoring an interim order.
Do you want to say that court had no authority vested in it to pass that order?
I'll not submit that way, my lord. But
Then
my
there will be no
only case that
jurisdictional error then.
only case that the court was required to see whether and status quo ante can be granted.
Can we
because of the change
can
of
we go and appreciate the factual
because
things?
because
We
of
appreciate the factual things. I don't think 227 is met for that. Only except if you say that the trial court was not within its jurisdiction to pass, or rather not empowered in law to pass an order of restoration. That is the only ground.
But that's one ground coupled with the fact that there is an order of the division bench of this honorable court, my lord, of the High Court. Similar facts, my lord.
Which way that order will bind this case? Just because party is same.
Not only parties.
Subject matter is different.
But the property is also same, my lord. Same in the sense, my lord.
These are regulated by two different agreements.
Different agreement, my lord.
But identical agreements, my lord.
Cannot be
the standard agreements, my lord, signed.
Then in that case, your case should be that suit is not maintainable. Then you should take a plea that the suit before the trial court is not maintainable in law, in view of the fact that for this identical matter they have approached the High Court.
That's true. Well, in fact, I offered because earlier this honorable court division bench is given him 10,000 rupees, my lord. If they can take some money and
that was because of the high-handedness.
That will not satisfy them. Even see, forget about the party. Even them.
Even till date, my lord, that 10,000 has not been paid.
10,000 is deposited in court.
If you can increase it to 10-fold or 20-fold, that he may reconsider.
Even that may be possible. I'll talk to.
Anyway, then what is to be done, Dr. Mojika? It seems
it will come next week sometime.
But then you have to satisfy this court on 227.
I'll try to, sir. I'll take a lot to the agreement.
There are decisions which said that you cannot bypass the statutory provision by resorting to 227. just because 227 can be invoked in certain situations, certain exceptional situations. Second thing, what this court thinks, this is the perception of this court. 227 is not there for enforcement of individual right. It is for ensuring that the court in subordinate or the subordinate courts, that is the word which is used there, remains within its bounds. Only thing is that if individual right get affected because of the, you see, action of the trial court, then only can be corrected. Otherwise, just because of enforcement of individual right, 227 is not at all available. Constitutional provision cannot be given status of statutory provision. You are bringing it down and equating with 115. You may have different opinion.
But there's a mistake, my lord. We've come under 36A, it seems.
36A, after the CPC is made applicable throughout the state of this thing, that part also please verify.
That's a defect, my lord. In the cost title, my lord, in the synopsis, they write 227, whereas in the cost title, they write 36A. My lord. So under which provision they have actually come before this honorable court is also.
See, this is a thing, the system prevailing all over. You file a petition, probably you also will do when you stand on the other side, by invoking many provisions of law, knowing very well that they stand at a different. Now that is what is happening, and then probably courts are also entertained. Now, that is what, that you see, like if you miss one, then
catch hold
you
of
go
another.
again.
I'll try to confine within 36A, my lord.
Confine, but in 36A also, then you have to take into consideration that decision of our High Court, the division bench.
Right.
Confine not 115. And if it is 115, then again that objection raised by Mr. Thapa will come. Well, it is in parametry, strictly parametry. Okay. The request made by learned DSJ. This is matter after when?
2 weeks.
2 weeks. 2 weeks, okay. After 2 weeks, okay.
2 weeks or 3 weeks.
After 3 weeks. After 3 weeks. Yes.
In the meantime, we will try to resolve also.
That is better. That is a welcome thing.
But the respondent is very difficult to handle.